May I please? Item 26, your lordship. I'm going to withdraw this petition because the petitioner got the relief.
Your name?
Monjus Soikia.
No, your name.
NN Upadhyay.
Mr. N.N. Upadhyay, the learned counsel appearing on behalf of the petitioner, submits that as the petitioner have already got the relief, the petitioner would not like to press the instant writ petition. Taking into account the above, the instant writ petition stands closed as infructuous. Yes.
May I please, your lordship? Lordship, on request of Mr. Patil, I am mentioning item number 24. It will be listed on next Friday. Your lordship.
Why?
Your lordship, Mr. Bhatti has left for Delhi today. Today he has left for Delhi, your lordship.
At the request of the learned counsel for the petitioner, matter stands adjourned for 4 weeks.
Obliging.
My lord, I'm making a mention for listing of a matter, my lord. One IA. The state has some urgency, my lord. My lord, can the matter be come on 17th? It's a vacating petition, my lord.
What is this?
My lord, a writ petition was filed by the writ petitioner. The matter was moved in 2020. Thereafter, it was for the second time, it was not listed. There was a, my lord, interim order not to release a payment for a particular date. That was also in 26/2020. That has left, my lord, but in 2021, the department has released some money in that tender, my lord. Otherwise, that matter is infructuous because the Honorable Court did not interfere in the tender process. The court said that no, this is a public issue, we will not interfere. But still, we would like to see the records that we're supposed to bring on records through an affidavit. We have filed an IE also some 3-4 months back. It is yet to be listed. There is no defect, nothing, but I don't know, my lord. So, my lord, there is some urgency. That's why,
Why are you mentioning before this spot?
my lord, bench 4 matter, my lord.
Bench, I am bench 5.
My lord, tender matter, my lord, is not. Then I'm sorry, my lord.
Tender matter is here. He is there. Some tender matters are here. But then also, don't you think that
No.
court number 5 would be the proper place?
My lord, I will do.
Make please, lordship. My lord, with the consent of the other side, my lord, I beg to mention item number 23, my lord.
23.
My lord,
Yeah.
I need to obtain some instructions from my client, my lord. It will take up after a week if lordship allows, my lord. There is no interim order as such, my lord.
Hmm?
There is no interim order as such, my lord.
At the request of Mr.
R.S. Mishra.
R.S. Mishra, the learned counsel for the petitioner, matter stands adjourned for 4 weeks.
Oblige, your lord.
May I please, your lordship? I am appearing on behalf of the people, my lordship. I beg to mention item number 37, lordship. Matter become infructuous, lordship.
You are appearing for
P. Uragai, lordship.
B. Buragwai.
Yes, sir.
Who are you? What is your name?
P.K. Gugoi, my name is.
Your name is not there.
Yes, sir.
But tell me, why are you saying that it is infructuous?
Already he instructed me, lordship. B. Uragai council already instructed me, lordship.
No, he may instruct you many things. You are not there.
Yes, sir.
Tell me why it is infructuous.
Already, respondent authority hold the account, lordship. Already, respondent authority open the account.
Account for what?
State Bank of India saving bank account, lordship.
State Bank of India.
Yes,
They were opened the account.
yes, sir. Earlier following the account.
The learned counsel appearing on behalf of the petitioner submits that the instant writ petition was filed on account of the freezing of the account of the petitioner by the State Bank of India. It is the submission of the learned counsel for the petitioner that in the meantime, the account has been opened, have been allowed to be operated by the petitioner. And as such, the petitioner would not like to press the instant writ petition. So taking into account the above, the instant writ petition stands closed as infructuous.
Highly applicable.
I beg to mention item number 47. Senior counsel is out of station. Kindly matter password for the day.
What? Nothing doing. Madam, I tell you, I don't grant adjournments on senior councils. You tell you have a difficulty, I'll accommodate you, not on the ground of senior councils.
Out of-
So you do it, your name is there?
No lordship.
No, nobody is there. We'll take it up when the matter is called.
With the consent of the petitioners council, my lord, I beg to mention item number 15, 16, 17. These matters may be taken at two, my lord. I am some personal difficulty from Dr. Settlement.
Item number
15, 16, 17. My lord, he has also my lord, consented with at two.
15, 16, 17.
serial.
Okay, you want it at 2?
My lord.
No problem. We'll have it at after completion of the order, admission matters.
Well-
Not at 2.
At number 1 from Muson.
Make this lodge. Lordship, this is a 2021 matter. And on the last date, 25/7/2022, the respondent number 2 had issued a notice to the petitioner and the other parties involved to appear before him on 3rd of August 2022. On such date, my lord, the petitioner had appeared before the ADC, and the ADC told that they will be fixing the matter for hearing on a subsequent day, and they will be issuing notice for the same. But no notice has been issued.
Your only prayer is that the respondent authorities, more particularly the respondent number 2,
My lord. To
should
dispose of the
dispose
mis-
of
yes.
your miscase.
Yes, ma'am.
That's all.
Yes, ma'am, that is the only prayer.
Dispose it.
Yes, my lord, that is the development, my lord. Lordship, I have asked them what is the outer limit within that they can do it. They said me that within 1 month they can do it.
Lord, it's pending
And
for the
is there
first
anybody
setting.
to be heard? Or only him?
No,
No,
my
the
lord, other
petitioner and the
people are also there
others are there, my lord.
because
Who else are there?
sale deeds were executed, my lord.
Only CP. CP real.
My lord, CP Realtors along with this respondent number 5 to 23. They are the residents of Gitanjali Heights. These are the people.
Okay, what is this miscase business?
In this case, my lord, what had happened in this matter is the petitioner's father had executed a power of attorney in favor of CK Realtors to construct a complex, an apartment. In subsequent to that, the petitioner's father expired. But my lord, this CP Realtors, they never approached the petitioner or other legal heirs for execution of a fresh power of attorney. Instead of that, they forged the signature of the petitioner's father and executed a number of sale deeds with the sub-registrar. When the petitioner came to know about it, he lodged FIRs before Chanmari police station and Dispur police station. And along with that, he had also filed a review petition before the circle officer. And the circle officer said that we do not have any review powers. As such, the matter was referred to the deputy commissioner in the year 2016, August 2016, White Annexure 9, so that the deputy commissioner can pass appropriate orders on the miscase, since the sale deeds were executed by way of a forged signature, my lord. And the father of the petitioner was no longer alive at that point of time when the sale deeds were executed. So that is why this particular miscase has been referred to the deputy commissioner by the circle officer.
Now show me where is the miscase?
My lord.
Right.
Sure.
No, this was the miscase.
Copy of miscase is not annexed with the petition. The order is at page 78.
No. Why haven't you enclosed? Dismiss it on that ground. Why haven't you enclosed that miscase? You want an order to be
Sorry, my lord. but
taken,
the
issued to the
notice-
deputy commissioner for passing an order for disposal of a miscase. As I could see from the records, there are a lot of litigations. Why should this court direct the deputy commissioner if there is so many litigations out there? You have arbitrary proceedings, you have something, there's some civil proceedings, everything is going on. Why should this court direct? Don't you have a suit pending against these people?
No, my lord.
Are you sure?
My lord, I mean, I have been informed.
Show me
by-
that miscase 109. Where is it? You have a copy of it?
Copy of order is there, my lord. I just
Oh,
have the copy of.
And I
the petition.
dismiss it on this ground. You have not enclosed.
The order is passed on 20th of.
I'm not
2016.
concerned with anything. We don't know what is the
Was also issued.
case. We have not enclosed the miscase. Then,
Notice is there, notice issued by the.
Madam, I'm not
circuit
concerned with all those things. I'm only concerned, why haven't you enclosed the miscase? The prayer looks very innocuous, saying that directing the authorities to decide the miscase. Why haven't you enclosed the miscase? Can this court direct, if it is a purely a civil dispute, then can this court direct the deputy commissioner to decide the miscase? If there is a case, question, as you say, it's a case of fraud being committed by execution of deeds of sale in the name of the father of the petitioner, then
That is why we had.
understood, but can the revenue court or revenue authorities decide that aspect as regards of fraud being committed? It is for the civil court to decide. And now getting an order from this court directing the revenue authorities to decide, or the sub-registry office to decide that, wouldn't that be the outreaching the jurisdiction of the civil court?
I pray for some accommodation. If within a week I may be permitted to bring on record the miscase by way
Okay.
of additional affidavit.
Madam, yes, the learned counsel, from a perusal of the records, it doesn't show that the miscase number 190 of 2015-16 is on record. And as such, without the said miscase, it is difficult on the part of this court to direct the respondent authorities to our consideration of the said miscase. The learned counsel for the petitioner seeks for an accommodation in the matter so that the miscase can be brought on record by way of filing an affidavit, additional affidavit. List the matter again on 21st of August, 2023.
Hello. Give to your judgment.
Item number 2 for admission.
Yes, Mr. Bhattakur, you have filed this petition FIR at Bokaro. Why?
Lordship, since your lordship,
Where did you pay the money?
your lordship buy, it is a bank transaction, your lordship,
So you paid the money by way of bank
Bank
transactions from,
from Bokaro, your lordship.
for? What is
your
the
lordship.
reason for?
The allegation is that your lordship, that the, for job, your lordship.
Understood.
That-
Now, where did you get that hold of the petitioner? You, as from the FI, it seems that you met the petitioner at Guwahati.
Lordship,
Then the petitioner asked you to make a payment to somebody.
lordship,
So you paid the money to whom?
to your lordship, the petitioner, your lordship.
You paid the money to the petitioner by way of bank transaction.
Bank transaction.
Where is
Your
the bank transaction?
Lordship will kindly, if your lordship go through the FIR, your lordship.
I am not concerned with the FI. Now,
No, your
where
lordship,
is the bank transaction to which you have made to the petitioner?
that your lordship, I should have your lordship brought by way of a record, but your lordship.
You have already filed your affidavit. You have not
Affidavit,
brought on record that
Okay.
aspect of the matter.
Lordship, this is because your lordship, I was not there when this affidavit has been filed.
Fantastic. Now you must be having a bank transaction.
Lordship. One for. Now, in the FIR, your lordship, just I want to point out, the, if your lordship goes through this, your lordship will. This is the certified copy of the FIR, your lordship.
Hmm.
The original. नहीं नहीं हेड में एकदम भी बोला एकदम दिस मुझे किधर पेज दिस
You paid 5 lakhs to the petitioner and 5 lakhs to one Razia Laskar.
lots total 10 lakhs.
Then
Now your lordship, if your lordship sees your lordship pays, there is an the main FIR, your lordship,
Hmm.
which they have your lordship annexed along with the I have page marked it here, your lordship.
23/12/2014. There's another 2 lakhs being paid
Lordship.
for what?
These are all for your lordship, this for the purpose of getting job, your lordship, I have,
So how much amount did you pay?
your lordship. As per my FIR, your lordship, I am supposed to get.
As per your FI, you have paid 10 lakh
10.
50,000. But here from these documents, it shows 12 lakhs. Then
Your lordship, that is the your lordship certified copy of the FIR.
Hmm.
If your lordship looks at page 5 of, I have marked it, your lordship.
Yes.
Lordship, it is in Hindi.
Hmm.
Your lordship, it says वादी द्वारा दिया गया ऑनलाइन आवेदन जो इस काम की मूल आधार है, मूल एवं अन्यों के साथ छाया प्रति संलग्न है. Your lordship, then kindly come to page next page. This is the main FIR, your lordship, which he has lodged. On the basis of this, your lordship, and your lordship, our difficulty is that, your lordship, we should by way of an affidavit, this should have been brought, your lordship. Therefore, your lordship, I am just pointing it out.
Hmm.
This is the FIR in which details I have mentioned everything, your lordship. It's a
Now, why did you pay this 10 lakhs?
10 lakhs, your lordship, as per my instruction, as well as in the, rather than the instruction, what transfers from the FIR, your lordship, is for this job, your lordship. Razia and Dharam Prakash. Both,
But you have stated that you have paid 10,50,000 to Razia.
lordship. But your lordship,
But these
I-
documents shows that 5
Yes.
lakhs have been paid to the
Yes, your-
petitioner.
in this main FIR, your lordship,
Hmm.
page 6 onwards,
Hmm.
because there is details of whom I have paid, your lordship.
Hmm.
And the FIR, your lordship, annexed by the petitioner, your lordship, this is an abstract of the main FIR, your lordship.
That is not the entire file.
Entire FIR, your lordship, that is from page 5, 6 onwards, your lordship. And that is why I have shown place,
Are you saying that the FIR, which is a part of the record
lordship,
of the revision petition or the writ petition,
lordship.
is not the actual FIR?
That is the gist of the FIR, your lordship, which
Oh, not the actual FIR?
No, my lord, we have got it from the client, which is the actual FIR as per.
No, no, your client may give you something else. I'm not on, but is this the actual FIR? Have you got the certified copy of the FIR?
Right now, I have no.
But the FIR says, which he has
But yeah,
shown out.
It was not supplied to us.
Lord.
The-
that's there.
that's
I have a
FIR.
copy.
That they are claiming, I have to take instruction whether this FIR is, because the FIR we have got long before.
But it is a translated copy of the FIR.
That we have annexed to the old one.
Even otherwise also, your lordship, even if we accept what has been, since that has not been brought to record by
I
me, your
have the
lordship.
honor to inform you that one Razia Hatigao, which is a private tutor and also running a coaching center at Hatigao with her husband Nurul Amin in the name of Gap. So and so near Iman had duped me along with other 2 friends. No, this is your FIR.
Even your lordship, if we accept this as an FIR, your lordship, there is one, my submission will be this, your lordship. Ultimately, your lordship, FIR will not be an encyclopedia, your lordship. It will be in the investigation whether he has any role to play, or he is the, your lordship, part of the racket, your lordship, who is collecting money or not, your lordship, for job, in the name of giving job. That will be disclosed in the investigation, your lordship.
No, why have you paid the entire money out here? Every transaction happened out here.
Lordship.
Then why on earth did you file it out there in Bokaro? The investigation could have been very well done out here. The problem arises, the state of Jharkhand is not
Lord.
represented
Lordship.
because of all these things.
Lordship.
They are not bothered with this case of 10,50,000. Why will they spend money on the lawyer?
Lordship.
Then why did you file it out there?
Lordship, since it is a bank transaction, your lordship, that's why.
No, bank transaction, no. It otherwise shows your malafide intention. It is a vexatious reason for which you have approached out there at Bokaro.
Your lordship,
You did everything. You came over to Assam. You asked these, met these people. You made the payments out here. Everything has been done. Where did you hand over the check?
lordship. That is the cash deposit, your lordship.
This can't be cash deposit. The documents which you show are checks. This doesn't show any bona fide on your part.
But ultimately, your lordship will
No,
kindly
no,
see,
no,
even
no, no.
assuming your lordship.
No, if the law is there, this law needs to be changed out there. And you see, these are check numbers by which we have done. Check number 180254. One is 180255, which is in the name of the petitioner.
Lordship.
You have paid 5 lakhs, whereas your draft FIR, which have been enclosed out here, does not show that. Kindly see here. This FIR is on the basis of this document. Kindly see
Lord.
page 25.
Of the petition, your lordship.
Yes, Annexure 2.
Lordship.
This is the FIR. With due respect, I so and so from Bokaro Steel City, so and so would like to share some information related to a fraud case in which I am a victim. Sir, with reference to one of my friend, Dharam Prakash, now I am a victim of Guwahati-based Indian Oil Corporation Limited fraud case. Sir, when
This
I
is
was
it.
in search of a better job, I contacted many of my friends to get information whether there is a job vacancy in his respective place based on my degree and experience. And among them, I contacted one of the engineering college friend, so and so. He suggested me that he is in contact of a lady, so and so, an agent who works for some of Indian Oil Human Resource Department people for backdoor recruitment at Guwahati region. He told me that that if I go for the executive grade, then I will have to pay 5 lakhs. And if I go to the executive grade, then I will have to pay 10 lakhs and more. And he said that if the amount is not paid by due date, a fine of rupees 50,000 will be imposed on the candidate. Sir, as per the said instruction, I paid the amount of rupees 10 lakhs for backdoor recruitment process, but I was late by 2 days. So Razia so and so charged me rupees 50,000. So when I saw nothing happening in the case of recruitment, I said to Mr. Razia, yeah, so here this document, this line clearly shows that you have asked the entire money from Razia. So and so, backdoor entry of so and so, so and so. And now she says that it is not possible to return you the money because of the recruitment is under process. So I cannot what to do. The situation is suffocating. I took loan from my father and so and so. There's no mention that you paid to the petitioner.
Lordship, that is an online FIR, your lordship, online, your lordship, that is what my. Lordship. But your lordship, since it is not, I have not brought on record, your lordship, probably your lordship, they will not, therefore your lordship, I will not harp on it, your lordship. Because ultimately, your lordship, that will have to be brought on record by way of an affidavit. On instruction, I am submitting this, your lordship.
No instruction, all these basic. Is there an annexure out there?
Yes.
No, this court has serious doubts on your bona fides out here, taking into account why have you finally everything you have come, you came to Guwahati, you made the payment out here, everything. Then why on earth now you are saying all these things?
No, your lordship will kindly see your lordship, that even if your lordship, that for filing and lodging an FIR, your lordship, if you file it in Bokaro, your lordship, then also your lordship, it is not that since territorial jurisdiction is not there, your lordship, Bokaro police has no power to investigate.
No. The Bokaro police station may have some jurisdiction. I'm not saying on that. I'm not saying that Bokaro police station would not. But see your bona fide out here. Wouldn't this be a case of an amount by which you want to use the process of law, the criminal law, by asking this, by filing the FIR out there, thereby harassing these people?
No, your lordship, that
You
is
have
not
not
because
got the
I
money,
had
so
to come here. Your
why,
lordship.
you came, you could very well come to Guwahati. You could file out here.
No,
Now
your-
tell me, why have you filed out there in Bokaro?
Lordship, I have filed because your lordship, I have transaction were made, your lordship, from Bokaro, your lordship.
How do you say so? There's nothing mentioned
That-
out there in your
That,
FIR.
your lordship, that is why I am referring to that particular FIR, your lordship, which is part, I say.
That
your-
is not an FIR before this court. This is not the
That
FIR
is
we
why
have.
your lordship will have to.
We have
forward
only
a record,
looked,
your
we are
lordship.
to look into this particular document as it is.
Ultimately, your
You
lordship.
had the right to file your reply. You have filed your reply. There's nothing mentioned out there.
Lordship, then your lordship also, your lordship will have to see the record, your lordship, investigation, what they have found in the investigation.
Why should I look into the records,
Because
seeing your
lordship,
bona fides?
ultimately, your lordship, investigation will reveal my bona fide or your lordship, malafide, your lordship.
You could have very well filed it out here if somebody has
And it is
taken
not
money
the
out
case
there.
that I have not come here. They have filed the complaint case against me, your lordship, here.
Let them file whether I'm not on
I
that.
have come, your
That
lordship.
matter is not before this court as regards
A
they.
person can have, your lordship, can feel that I will lodge an FIR here since I
You
have.
give the money to somebody out there and that person concerned have not returned you the money in lieu of an illegal appointment. You know,
Lordship.
you have approached out here with a backdoor entry,
Lordship,
meaning thereby you have committed an illegal act.
Lordship, I don't deny all these
Then-
things, but all that will not obliterate your lordship, their offense, your lordship. That's what my submission is, your
What is
lordship.
their offense?
That is the offense, your lordship, which I have alleged, your lordship.
That they are in a record of
Yes, your lordship.
job.
Yes, your lordship. Your lordship may feel that their materials is not there, but my case is that, your lordship. And your lordship, so far as this jurisdiction point is concerned on the police, your lordship, that has been clearly laid down by the Honorable Apex Court. That's not a ground for challenge, your lordship.
No, they are not challenging it.
That is they. that is
They are
what-
not challenging on the jurisdiction out
Lord.
there, no. But I am saying that why you have filed it out there where everything happened here.
Lordship, part of the cause of
There's no
action, in
part
my
of this.
understanding
No.
is, your lordship, maybe that, your lordship, since I have paid it, your
On
lordship.
one hand, you are saying that the entire amount has been paid to this Rajya, whatever mean. You have paid to somebody Rajya. But on the other hand, the amount out there which have been shown by you today, these documents shows that 5 lakhs was paid to him on some
Yes.
amount. Yes, there might have been payment of 5 lakhs for some other reason, but does it constitute that there has been any inducement being made by them to the effect?
That is, your lordship will
It's a
reveal by the
very simple
investigation.
case of a
Unless-
vexatious litigation.
Your lordship,
Fire.
your lordship will kindly see, your lordship, until and unless your lordship go through the what has been, what has
I'm
been-
not going to go to anything out here.
Lordship.
Here is a case out here, this, on the face of it, it appears. Then when did the FIR happen? When did you lodge the FIR?
I lost it, your lordship. My FIR is, your lordship, lost on, registered on, your lordship. 10/1/2016, which I have written on 50, filed on 15/12/2015.
When did you pay the money?
Your lordship, that, your lordship, date.
When did you meet them? And they said that they are not going to. pay
Lordship,
you.
lordship, that- In 2014, this whole process started, your lordship. That's why FIR says, your lordship, from 2014 to 2016, the cause of action, your lordship.
You lodged the FIR in 2016.
Lord, it registered on 2016, on 10/1/2016, and I have written to them on 15/12/2015.
On
15/12/2015, I have written to them
15/12.
2015, and they registered it on 10/1/2016. Some translation.
Because from these documents, which you have placed, shows that you have paid some, parted with around 15 lakhs. Which, however, is contrary to what has been recorded out there in the FIR.
I have transferred the money to Dharam Prakash Singh Axis Bank account with account number so and so on 11/5/2015. That is my statement. Transferred an amount of 50,000 from Axis Bank so and so HDFC check to Rajani Laskar Axis Bank. Both, your lordship, I have paid, deposited. I paid total amount of rupees 10,50,000 from Dharam to Dharam Prakash Singh, Dharam Prakash friend and Razia Laskar's bank account, the proof of which I have attached herewith as last page. In fact, your lordship, in that FIR, detailed FIR, your lordship, I have annexed everything, your lordship. After payment of complete money on 26/5/2015, an exam was held in the institution of Razia Laskar Husband by Indian Oil Corporation Limited, situated in Guwahati. During this exam, one person came whose introduction was given as official of Indian Oil Corporation Limited. 4 people appeared in the exam, me, so-and-so, so-and-so, and so-and-so. The first page of the question booklet provided in exam was captured by me through my mobile camera, the photo of which I have attached along with the. These are the detailed statement of the details of the FIR, your lordship. I have stated everything, what I have done, your lordship. That is also I have stated, your lordship. Apparently, your lordship, case should be registered against me also for this. After completion of the exam, I asked the officials of Indian Oil Corporation Limited that when advertisement for the post and the result of this exam will out, then the official replied that after 1 week.
What are you reading?
That is, your lordship, the translated copy of that,
You have not given it to me.
lordship. It is there.
Where? Oh, I don't have a
Typed of the translated copy of the.
No. Oh, yeah. Oh, yeah. This was the one which you have given.
Lords. It was in Hindi, I have translated it. Hindi is in page 6.
But how do we know that this portion of 15/12/2015 is a part of the FIR?
Lordship, that is why, your lordship, I have shown this page 5, your lordship, the Hindi. Thus before that, your lordship.
You are saying this one now, read it, the third page.
भादी द्वारा दिया गया ऑनलाइन आवेदन जो इस काम की मूल आधार है, मूल एवं अन्य के साथ छायापत्री संलग्न है. It was annexed the main FIR, which is the छायापत्री means, your lordship, extract.
Mr. Bora, you have not enclosed the entire FIR.
We have received the FIR, whatever.
See, if this is the certified copy.
Yes, this is the certified copy.
Kindly look into it.
Yes, my lord.
No, why have you not enclosed the entire FIR? Kindly see this. This is the certified copy. Kindly see there. That a Hindi portion out there. On top, no, that page. No, the next page on top. Ask your, if you, yes, read that.
द्वारा दिया गया ऑनलाइन आवेदन की
जो इस काम की मूल आधार है.
There is only an enclosure.
No, that becomes a part of the mool Aadhaar hai means that is the part of it. That is the main thing.
Yes, we have received these FIR as a certified copy. But they have not received that has not been furnished.
It is mentioned out there, and more particularly, Mr. Bora, why haven't you enclosed that portion of it in your FIR? Kindly see what you have done in your petition.
All of that portion was not available when we have got this.
This was very much available. That is a certified copy available to you.
Certified copy, but it was that the enclosure was not made available to us.
I understand, but why in your petition, the entire that 3 pages of the document is not a part of the record.
Oh, that
Why haven't you done that?
we have not that, yes. But we have the main portion, we have annexed it.
No, well, the main portion we are not concerned because that portion has a lot of relevance taking into account that there it says that the main FIR is a part of the record.
But that we don't know, my lord, at this stage.
No, it is there. It is written out there. Whoever has filed it.
That is the Badi Dara Diya Gaya online Abedan.
Hmm.
Online Abedan.
जो इस कान की मूल
जो
आधार
इस कान के
मूल आधार
आधार
है,
है कुछ साथ मूल एवं अन्य की साथ
छायापत्री संलग्न
संलग्न है. That was the annexer.
So no, that is not the anchor. That is the actual FIR and they have only made a gist of it.
So whatever we have received, my lord, we have annexed. it.
You have not enclosed the
Yeah, that's true.
Yeah.
And for the records, my lord, they have filed an FIR, affidavit. In affidavit, there is no mention about these things, my lord. They could have rebutted that.
Now can this court say that no, in view of this disclosure out there, can this court now say that, okay, we are not going to look into the annexure to the FIR, which actually forms
No,
the.
they could have annexed it in the first affidavit also.
Oh,
That may be the development, we don't know. So let them bring, we'll also
No,
take
first and
instruction.
foremost, why haven't you filed the entire, that 3 documents, that 3 pages, why haven't you filed it?
That's maybe inadvertently that has remained, my lord.
No, it can't be. There has to be an explanation out there. There cannot be an inadvertently done. Why have you only enclosed this? There's some compromise deed you have enclosed. Why
Yes,
haven't you mention any all other?
that is the only the part is the that is not developing anything, only there is an annexer.
No,
But
that is
we
a-
have not
no,
provided.
no. That
When we have applied
No,
for the
Mr.
certified
Bora,
copy.
that particular document aspect clearly shows that the FIR is, that was the gist and the main FIR is a
Maybe.
part of it.
Maybe, my lord, but in their first affidavit, they have not rebutted that there is it's just a gist. They have simply admitted that part. They have admitted this is the FIR, 406, 420 has been made out. In the first affidavit, there is no mention. There is a part of the gist of the FIR we have been enclosed. Not a single mention in their first affidavit. Now they have brought in, there is something there to more. I have to take the instruction from my client that is there anything to be more? Is there any enclosure to the original FIR?
It
But
is
the-
all on the, from your own certified copy, it says that there is an enclosure.
Yes, maybe, my lord.
What
but
other
the-
instructions are required?
So we'll ask for the original enclosure, their original thing.
We vacate the stay. The stay can't remain if you have not enclosed the entire thing.
So they have not admitted that whatever the document they have said.
You should have enclosed the entire thing. This is not the
No,
way
this
how
is
you,
not- not
wouldn't
the-
this amount of suppression of material facts?
No, that's that is.
Absolutely. This is a case of suppression of material facts.
How can we admit it? That's an-
Why haven't you enclosed the entire all the 3 pages out there? What is wrong with this not to enclose the entire? I would have understood. Okay, you may not have the enclosure with that. Very well, fine. But why the 3 pages were not enclosed, which
That is
was
only
given to you?
inadvertently,
And
madam.
you have selectively only enclosed the first.
No, don't,
page.
do. We are not selectively enclosed. That
That
is
absolutely it is.
inadvertently. That is
No,
your
Mr.
presumption.
Lawrence, it is the
That is
first.
the presumption of your lordship that this selectively. Otherwise, I would have not given it to lordship. Otherwise, now I have not given it to your lordship today, if I would have been selective. That I would have not given
You
it to
have
lordship.
now an option when this, the other document has already been placed
They have
out here.
placed it. They
No,
have-
the-
we have- we
when
don't
the
have the
other
copy.
document is
We
out
don't
there,
have- I could have given the only one page to you. If it is selective, why lordship is putting the word selective then?
absolutely it is a
If
selective.
that's why my bona fide, I have placed the judge, right now I have placed it. So why I have placed it?
This is a
If it's my-
selectively which
I
has
have
been
no
done.
bona fide. You can dismiss my petition on that ground, but you don't use this selective, my lord.
I will.
You
I put.
dispute it,
I
whatever
can
you
put
do,
it. If you
do it.
want, I can put it on.
Yeah, put it all. But you don't use the word selective, my lord,
I
because
will.
right now
No.
I have placed the original copy where it has been mentioned.
You have not done that entire.
Whenever the court asked it, I have asked it. I have placed it. Had I have the intention, I could have not placed it, that part. And the gist of the original FIR, they have not rebutted in the now they have brought it some of the document.
But when
which
you
is
have
given
not
us
enclosed
for-
the entire thing, let's see who has filed the petition. So petition kune file করছে?
And the document they have placed it before, we have not submitted also. In the first affidavit, there's no mention about these facts. Now they have brought in the new facts. There may be a second affair also. We don't know. The affair he's telling about. Why they are silent about in the affidavit?
This particular document has not been enclosed the entire in total.
Yes, that I have admitted.
Close that,
I
yeah.
admitted. I have only objection regarding the malafidness on my ground. That is the only objection I have put it. That the malafidness. I have no malafidness regarding that.
Malafidness of what?
The lordship has put it.
Absolutely. When there were
That's
three
what I'm
pages,
saying.
no, Mr. Counsel, kindly appreciate. When there were 3 pages out there, why you have only enclosed one?
Part I have enclosed.
No, can you do only one part?
Yes,
When the entire
main-
document is
main
there with
part
you?
We are doing it every day. We are doing it in the High Court, the main part in the FIR. But yeah, we are doing it every day. That is the procedure going on. The main part of the FIR. We don't need to enter FIR, the first part of the day, where the format. Format we don't enclose everywhere. We always enclose the main part of the FIR. That's going on. And that is why I have placed it. Now, if I had some malified intention, I have said that I don't have that. I have placed it before your lordship right now. Then I have found it, yes, there is some annexer.
The-
So that's what I've said, that I have to take the instruction from my client, is there any annexer to that? Because they have also not, in your affidavit, nowhere it should mention there's an annexer or there's just original FIR to that effect. They have not mentioned in the earlier FIR. So I was also under the view, there's no mention. Otherwise, we have brought it. What is my point? I could have.
Who is the filing authority, counsel? Who is this Chandra Mita Chaudhary? Where is she?
My junior. My junior. I take the responsibility.
We'll ask the authorities to make an inquiry with her. Submit a report before this court. Why only that portion has been done?
It is going on, that practice is going on.
Let it be, but then also we'll have an inquiry.
Yes, have it.
When the matter has been taken up today, it transpires that the FIR, the certified copy of the FIR which was obtained by the petitioner contained how many? 3 or 6 pages? No, 3 pages, I think on both sides, no?
Total 5 pages.
5 pages. However, in the records, only 1 page of the said FIR pertaining to Bokara PS case number, Bokara Steel City Police Station case number 8/2016, registered under section 406 and 420 of the Indian Penal Code, have been enclosed. It further transpires from the annexure 2 to the petition that a gist 2 to the petition. That the allegations so made in the FIR the case, the allegations so made by the respondent number four have been mentioned. On a conjoint reading of Annexure 2 enclosed to the petition, along with the certified copy of the FIR, which the petitioner had obtained at the time of filing of the writ petition, it transpires that there's a mention that the main FIR, so filed by the petitioner, filed by the respondent number 4, forms a part of the said FIR. It further shows from paragraph number 5 of the writ petition that FIR dated 21/2016, so lodged by from paragraph 6 of the writ petition that the copy of the FIR, impugned FIR dated 10/1/2016, lodged and registered before the Bokaro Steel City PS, has been enclosed. There is no mention in the said paragraph number 6 or in any part of the writ petition that only a part of the FIR was enclosed. Only a part of the FIR containing the relevant portion has been enclosed. This court further finds it relevant to note that the contents of Annexure 2 of the writ petition, as well as if the main FIR is taken on record, the reference of which has been mentioned in the certified copy so obtained by the petitioner, it would make a hell of a difference Mr. S. Potagore, appearing on behalf of the respondent, number 4, submits that he may be given an opportunity for filing an affidavit, bringing on record the contents, the entire FIR, the certified copy of the entire FIR, including the enclosure, as well as also a translated version of the same. List the matter again on when.
After 10 days, your lordship.
List the matter again on. Thirtieth of August, 30, 30th of August. The affidavit be filed by 28th of August, 2023.
Yep, yep.
Item number 3.
Yes.
In this case, my lord, this petition was filed against the order of the Assam Board of Revenue. In this case, there is a observation that
You are challenging some order of the Assam Board of Revenue. Why?
because, my lord, the Assam Board of Revenue, with certain observations, directed the appellant to go to the civil court. And in fact, my lord, we have already filed a civil suit. And suit is
Omia Kumar Bora, Boro.
for water. He died in Namington.
What is the submit here? As the title of the land in question is disputed amongst the brothers only. Secondly, possession over the disputed by the appellant have not been proved by the appellant. On the other hand, when both the parties raise the question of genuineness of the gift deeds executed via and any competent order in respect of the legally transferred only can be passed by the civil court. So we are not inclined to pass any observations as regards the deed of gift.
That is correct, madam. But certain observations were made here, my lord. That is the problem. Actually, this petition was filed, thereafter the civil suit was filed. Civil suit is pending. That is correct. Now, here, my lord, certain observations made which may affect the decision in the civil suit, because they will place the
Which observation?
here, my lord, that certain gift deed, originally, my lord, the gift deed was made in favor of the petitioner, my lord. His name was mutated, everything was done, and holding number was also sent. Subsequently, my lord, before death of the mother, that is mother of the originally mother was the original owner, my lord. They also obtained a gift deed, and they applied for mutation. And mutation, circle officer refused. Then they came before the appellate court. Appellate court observed, your lordship may be pleased to see at page 32. The heirs having equal rights over the paternal properties, therefore, by accepting the application order, it is so and so passed by the circle officer, Guwahati Revenue Circle in mutation case number 7, where the mutation was granted, is cancelled, and parties are advised to approach the honorable civil court for partition of the property. How this ADC passed that the heirs have equal right? It is the mother's right, my lord. Mothers have gifted the property to me. And other mothers, several properties were that they were given some other property. Now, after 9 years of my gift deed, when the mother has no right to execute any further gift deed, my lord, they obtained a gift deed in their favor. And paid for.
So your case is that the gift has already been effected, thereafter the mother can't gift it.
Yes.
So
Yes.
now they are asking for mutation on the basis of the second gift deed.
Yes.
They are the appellant
Yes, yes.
and you are the,
I
so
am
their
the-
mutation was not granted.
Mutation was not granted, but the ADC, after the order of the ADC, my lord, revenue board also observed that they let the mutation remain in the name of the dead person, that is the mother. That is kind of the problem here. Last line, my lord, it is hereby ordered that the disputed land shall remain in the name of the Aljoy Patadar,
Where?
that is page 32 last line,
Page 39.
32, my lord,
Also, they did not interfere.
32.
Okay.
Last line, my lord. It is hereby ordered that the disputed land shall remain in the name of the Aljoy Patana Srimati Pramila Boro, wife of late so and so, till final order is passed by the Honorable Civil Court. That is actually, my lord, my problem.
So
Actually,
your thing is that if it is remains in the name of a dead person,
my name was already mutated. Everything is done. These observations, my lord, may affect in the decision of the civil court also. In the civil court, my lord, before his death, that is the petitioner's death, evidence was also complete.
but Mr. Kulita, wouldn't it be that the civil court shall always decide the horse, what is the finding of the revenue court?
Exactly, my lord. I want a observation from your lordship that his decision will not affect the judgment in the civil court. That observation only and dispose of this petition.
It is a question of cancellation of the mutation.
Yes.
So
Now,
you had the mutation on the basis of the original gift.
Yes.
Thereupon they came up and they wanted the mutation and so, which was in view of their two gift deeds, the ADC did not do anything, said that you go to the civil court. In the meantime, let the mutation be there in the some other's name. Yes, who is appearing for the revenue?
they are not repairing, my lord, for last so many days.
No, I'm not on that. The government. Whether service is served, service is made.
Yes, they have filed also affidavit.
name has been sold, lordship.
Huh? No, it's okay. Mr. Henrik, tell me here. The land was in the name of the mother.
Okay.
There's no denial to that fact. After the mother, it is the claim of the petitioners herein that the land was gifted to the mother, to them. And on the basis of that, he got the mutation. Now, thereupon, the mother again gifted the land to other people, the respondents, private respondents. And these private respondents wanted their land to be mutated in their name. And therefore, they file an application and they say that here is a case as to whether the gift, this gift or that gift is good or not. It is not known. And as such, reverted their name back to a person who is dead. Isn't it?
Yes.
Against that, they file an appeal. They say that no, whatever may be, let the civil court decide. No, but did not interfere with this order. Now, can there be a mutation knowing fully well that the person is dead?
Dead person. Dead person cannot be mutated.
When did your mother die?
That is a 2009 matter. And my gift deed was registered gift deed, my lord.
And their gift deed is? Their gift deed is not registered.
No, subsequently registered matter on commission. At that time, mother was on the deathbed matter.
So the second gift, but your case is that they can have been, once that already there being a gift deed, the property has already devolved.
Right. To execute the second gift deed.
So you are only worried with the observations so made.
Yes, my lord.
What are the observations you are saying?
These observations, my lord, that they let this mutation remain in the name of the that, and all the heirs are the
Where?
all the heirs have equal rights over the
The
land.
heirs having equal rights over the paternal property. Therefore, by accepting the application passed by the sale whereby mutation was granted is cancelled and the parties are advised to approach this.
And Assam Board of Revenue also made certain observation, my lord. Same type of observation. That at page 38, my lord. So how he get the gift deed in respect of the said land is full of security, palpably doubtful, and the said gift deed number so and so is absolutely fraudulent and making one and illegal.
Where?
That is at page 38, my lord.
38.
Assam Board of Revenue's order,
Which portion you are reading?
middle, my lord. So how he got the gift deed in respect of the said land is full of security, palpably doubtful, and the said gift deed so and so is absolutely fraudulent.
What is the suit you have filed?
I have filed the suit for cancellation of the.
What is the number?
Yes, okay.
And pending before whom?
Before the civil judge number 1.
Suit for?
Suit for the declaration, matter that their sale deed is illegal, etc.
And for declaration of your right.
Yes.
Give me that just a number of. The instant writ petition has been filed challenging the order dated 19/8/2012 passed by the learned Assam Board of Revenue in RAK number 165/2013, whereby the order of the additional deputy commissioner in RA/M 47/2012-13 dated 3/12/2012 was affirmed. From the facts narrated in the petition, it transpires that the petitioner that the land in question, which is a plot of land measuring 3.75 hours covered by Dag number 1946 of KP Patta number 1331, situated at village Sohor Ulubari Part 2 under Guwahati Revenue Circle in the district of Kamrup Metro, Assam, originally belonged to the mother of the petitioner. It is the claim of the petitioner that she had gifted, that the petitioner's mother gifted the said plot of land in favor of the petitioner by the registered deed of gift bearing registration number 4227/2000 dated 16/6/2000. The petitioner thereupon applied for mutation of the land as well as the house standing thereon, which were granted by the Revenue Authority as well as the Guwahati Municipal Corporation. Subsequent to that, there is another gift deed by the mother of the petitioner to the respondent number 2, 3, and 4. By the registered deed of gift bearing number, where is it? You have challenged in your FIR plaint.
That is in 2009, my lord.
You have the date?
Page number 13.
Huh? Page
13, my lord.
13. No, page 13 is his.
Okay.
I'm not on that. The other sale gift, where is it?
Actually, we have not annexed their deed, my lord.
You have the number? You must have filed a suit?
Yes.
Where is that suit?
Therefore,
Give me a copy of the claim. I'll look into it.
It is not there, my lord. But the suit number is title suit number 56/2013.
In the suit, you must have challenged the deed of sale.
Yes, sir.
At the deed, where is it?
Suit report is.
Ah, got it. By the deed of sale bearing deed, by the gift, by another deed of gift bearing deed number 12597 dated 13/10/2009. On the basis of the said deed of gift, the respondent numbers 2, 3, and 4 applied for mutation of their names in respect to the land. The said mutation was rejected by the circle officer, Guwahati Revenue Circle, in mutation case number 3463/2010-11 by an order dated 30/1/2012. The respondent number 2 and 3 and 4 thereupon preferred an appeal before the court, before the additional deputy commissioner Kamrup Metro in RA bracket M 47/2012-13. Wherein the additional deputy commissioner Kamrup Metro without deciding as to whether the petitioner would be entitled to whether the mutation granted in favor of the petitioner was in accordance with the provisions of law, or the respondent number 2, 3, and 4 would be entitled to the mutation, cancel the mutation, and reverted the name and reinstated the name of the petitioner's mother, who was already dead, as on 21/12/2009. Being aggrieved, the petitioner thereupon preferred the instant appeal before the Assam Board of Revenue, which was registered and numbered as 165 RAK/2012. The learned Assam Board of Revenue, by its judgment and order dated 19/8/2013, did not interfere with the order of the additional deputy commissioner and observed that it is the civil court who can decide as regards the genuineness of the gift deeds so executed in favor of the petitioner gift deeds, that is one executed in favor of the petitioner and the other executed in favor of the respondent number 2, 3, and 4. Be that as it may, there has been certain observations being made by the learned Assam Board of Revenue, which touches on the rights of the parties. Next. It is under such circumstances that the petitioner, being aggrieved by the order passed by the learned additional deputy commissioner dated 3/12/2012, as well as the order dated 19/8/2013 by the Assam Board of Revenue, has approached this court by filing the instant writ petition. It appears on the records that pursuant to the issuance of notice, there was a stay. There was a stay? No. No stay, no? It appears on records that this court,
Yes, my lord, there is stay.
what is that
On
stay?
3/2/2014, man.
Huh?
3/2/2014. Honorable Justice H. Roy.
Okay, so stays there. It reveals on record that by an order dated 3/2/2014, this court had issued notice and stayed the order dated 19/8/2013 by the Assam Board of Revenue in case number 165 RAK/K/2012, as well as the order whereby the order of the additional deputy commissioner Kamrup or order of additional deputy commissioner dated 3/12/2012 was affirmed. It further appears from the records that there is an affidavit in opposition so filed by the respondent number 2, 3, and 4. Wherein it has been mentioned that there has been various litigations in the civil court amongst the petitioner as well as the respondent number 2, 3, and 4.
165 RA.
I've heard the learned counsels for the parties. I've heard the learned counsel for the petitioner, as well as the counsel appearing on behalf of the respondent number 1. The respondent number 2, 3, and 4, however, are not represented. This court have duly perused the order dated 3/12/2012, passed by the additional deputy commissioner Kamrup Metro in RA (M 47/2012-13), as well as the order dated 19/8/2013, passed by the learned Assam Board of Revenue in RAK 165/2012. The findings by both the authorities, in the opinion of this court, that the dispute needs to be resolved by the civil court. Taking into account that there are certain disputes as regards the genuineness of the gift deeds. Seems to be a reasonable conclusion arrived at by both the authorities. This court further finds it relevant to take note of that in the meantime, the petitioner have also filed a suit being titled suit number
56/2013.
56/2013 before the court of the civil judge,
Number one.
Kamrup Metro number 1,
Now
Who-
senior division matter.
eh?
It will just senior division.
Senior division number 1, which is also presently pending, whereby the gift so executed in favor of the respondent number 2, 3, and 4 has been put to challenge, as well as the declaration of the petitioner's right over the land in question have also been sought for. You have sought for the declaration of your right. However, this court also finds it relevant to take note of that if both the authorities, that is the additional Deputy Commissioner Kamrup Metro, as well as the learned Assam Board of Revenue found that it is the civil court who has to decide. The same authorities ought to have relegated the parties to the civil court rather than cancelling the mutation and reinstating the name of the mother of the petitioner as well as the respondent number 2, 3, and 4, who already died on 21/12/2009. Under such circumstances, this court therefore interferes with the order dated 3/12/2012, as well as the order dated 9 passed by the additional Deputy Commissioner Kamrup Metro in RAM so-and-so, as well as the order dated 19/8/2013 passed by the Assam Board of Revenue in case number so-and-so, to the extent of reinstating the name of the mother of the petitioners as the petitioner and the respondent number 2, 3, and 4. Who had already expired then. Accordingly, this court therefore reinstates the name of the petitioner, restores the name of the petitioner in respect to the land in question, and such restoration shall be subject to the outcome of the civil suit. This court further observes that the restoring of the name of the petitioner in respect to the land in question shall not confer any equity upon the petitioner in respect to the land in question, which as observed above shall be subject to the outcome of the suit above mentioned. This court further finds it relevant to take note of that in the order passed by in the judgment passed by the learned Assam Board of Revenue dated 19/8/2013, there has been certain observations so made which may affect either the petitioner as well as the respondent number 2, 3, and 4. This court is of the opinion that taking into account that the title of the land is pending before the civil courts, the said observations that the title of the land is pending before the question of title over the land in question, as well as the genuineness of the gift deed executed in favor of the respondent number 2, 3, and 4 is a subject matter of consideration before the civil court. The observations so made by the learned Assam Board of Revenue in the judgment dated 19/8/2013 shall not affect the adjudication in title suit number so and so. With the above the instant disposed, the LCR so called is returned.
Second deed number, my lord.
I gave it before you found it.
May it please your lordship.
Hmm.
My lord, matter pertains to drop teacher, my lord. The petitioner was initially appointed in the year 1991. There was an exercise carried out on 1/2/1994 to provincialize the services of teaching and non-teaching staff of the concerned school. At that point of time, the petitioner's name was dropped. She was not, her service was not provincialized. Thereafter, my lord, certain rounds of litigations took place. Eventually, my lord, her case was directed by this honorable court to be placed before a high power committee, which would take a call on this matter. Now, here, my lord, the petitioner placed her application before the concerned authority. That, if I take your lordship to, that is at page 34. Now, here, my lord, she narrated her involvement with the school, the entire sequence of events when she was appointed and the provincialization and her prayer. That is at page 34. Now, vis-a-vis her application, my lord, there was also a verification report to be submitted by the principal of the concerned school, that is respondent number 6 to the authorities. That your lordship will find at page 39. Now, if your lordship kindly sees at page 39, final report, a penultimate paragraph from below at page 39, this is the report of the principal. Your lordship has got this final report written down below. There, my lord, what has happened, it has been said that, sir, after all findings, finally, it has come to my notice that all the papers and documents submitted by the petitioner candidate Srimati so-and-so, drop assistant teacher of so-and-so, is true and correct. But eradication of teachers' attendance registers for the year 1991 and 1992 has been creating confusion upon the matter whether the said teacher had continued her service since November 1991, that is from the date of her appointment, or not. I therefore submitting my report and have been sending back all the papers before you for your kind perusal and convey my findings in order to help you in case of submission of the final report to the higher authority and oblige. Now, pursuant to this verification report, my lord, this impugned decision was taken by the high power committee, which was conveyed. That is at page 41. Now, the second paragraph that reads, the matter of so-and-so was placed before the committee. The committee finds that the petitioner joined on 12/11/1991, and as per the record of the concerned headmaster, the teachers' attendance register for the year 1991 and 1992 are not available in the school. As such, it is in doubt whether the petitioner was attending the school from the date of joining or not. Therefore, the committee did not recommend the name of the petitioner as dropped assistant teacher of the school. Now, my lord, I'll just point out one thing. At page 42, there is an annexure, annexure L. Now, this is a certificate that was issued by the concerned headmistress back on 24/7/2008, wherein it was certified that the petitioner herein is serving in the school since its ad hoc period with effect from 12/11/1991 as per record. At the time of provincialization, the post she hold had been found dropped. The school was provincialized with effect from 1/2/1994. My lord, regardless of the fact that the headmistress subsequently, the headmaster subsequently had given a verification report that the school attendance register for 91 and 92 were not available. But there was a certificate by another headmaster prior in point of time who had given a certificate that she was in service, and this certificate, my lord, was enclosed by the petitioner in her application, which she had submitted before the authority. That, my lord, I had pointed it out to your lordship. That was at page 34.
Mr. Chakravarti,
My lord,
first and foremost,
my lord,
in 1997 to 2001
Right.
or 2004-5,
Right.
there was a process of provincialization of the drop teachers.
yes, my
You were not there.
my lord, at that point of time, my case was not within that ambit.
Because the provincialization of the school happened in 1994.
Yes, my
So thereafter, in view of that Jivan Rekha's case, there was certain attempt, there was a particular proposal by which the high power committee could to look into.
yes.
What happened then?
My lord, then it was, my lord, the criteria that was adopted was that an incumbent had to render 2 years of continuous service just prior to the date of provincialization. And if that is brought to the satisfaction of the high power committee, if the high power committee is satisfied on the aspect that the incumbent had served continuously for a period of 2 years just prior to the date of provincialization, the incumbent would be entitled to be provincialized, regardless of the fact that the teacher was dropped. Now, the case of the petitioner here also could have been considered on those lines, but for the fact that the verification report that was submitted by the headmaster, everything was taken to be true. The application submitted by the petitioner, the contention that she had served the school, all these things were taken to be true in the verification report. Only thing that the headmaster said was that the school attendance register for the period 1991 and 1992, not only in regard to petitioner, the entire school attendance register were not available or were not traced out. That's why it had created confusion. Now, petitioner had also submitted an application before the same considering authority. Now, in that, my lord, the certificate that I have just pointed out to your lordship, that certificate was enclosed, and that certificate was also by the,
Certificate is of 2008.
yes,
2008, what is the basis on which he has stated? If that certificate was not available at that point of time, there was no records on what basis the headmaster in 2008 stated. We are concerned about the period from 1991 to 1993.
my lord,
Because the provincialization happened in 1994.
yes, my lord.
And when the earlier headmaster said that there was no records out there, on what basis does this headmaster in 2008, whether this is the same headmaster?
No.
It couldn't have been.
My lord, the headmaster who said that there was no record was subsequent in point of time. The headmaster who said that she has been in continuous service and issued the certificate, this is prior in point of time.
It couldn't have been.
2008 is
No,
prior in point
It
of time.
couldn't have been because in 1991-93, your provincialization happened in 1994.
Yes.
So when the 94 and this period was taken immediately after the Jivan Rekha
Yes, my lord.
thing, it was done. And there was a high power committee in terms with the guidelines laid down therein.
Yes.
There, it was not found at that point of time that you had these 2 years of.
Yes.
Now, what is the basis in 2008, this headmaster coming up and saying that, yes, she was working from 1991?
My lord, insofar the basis of this certificate is concerned, my lord, that of course the petitioner will not be in the best position to answer. The principal, my lord, is a party in this case.
Understood, the principal is a party, but the fact is whether the principal had done it on the basis of some contemporary records, because he couldn't have had the records because earlier the high power committee and the inspector, even the inspector's report, which you have just indicated,
My lord,
there was no documents as regards the attendance for the period from 91, 92.
no, my lord, that is subsequent in point of time. The report that I am pointing out by the headmaster, that is of 2015. It may so be that in 2015, after 2008, when the certificate was issued, thereafter this records might have got dilapidated or destroyed or whatever. Now, in 2008, which is prior to 2015, a certificate was given.
No, where are the documents for that?
My lord, that document,
If
of
the
course,
documents are not that, how can you say on the authenticity of that person concerned?
my lord,
Because
that-
you see, this exercise was carried prior to 2005.
yes.
The entire exercise was carried prior to 2005 on the basis of Jibanda.
But-
So on what basis do you now say that these are documents or how can this court blindly take into account
I
the
understand.
certificate of 2008?
I understand, my lord. To that effect, my lord, there was an order of this honorable court the previous day, where, my lord, a direction was given to the department to find out whether in regard to the provincialization of the other incumbents of the school also, if the same criteria was adopted or there were some cases where some incumbents were left out. There was a direction from this honorable court on previous dates. Kindly, if your lordship peruses that order. Now, here my only, my lord, contention would be that obviously, my lord, they say that there is no record to substantiate that my continuous service for 91 and 92. 93, there is no issue because 93 continuous service that is there. Only thing they are talking about is that period of 92, because I am to establish that my continuous service was from effectively February 1992 to February 1994. 1/2/1994 was the date of provincialization. So I
Yes,
am,
Mr. Khatania, what have you done to the order of 12/6/2023?
Pursuant to the 12/6 order, my lord, the current present headmaster of the school, she submitted a report, my lord. And that report is similar to the earlier report, which was annexed in the petition, 2015 report. I have got a copy of that report, my lord. That report, she admitted that that certificate, that my learned friend is lying, that certificate was issued by her predecessor.
Understood.
That is, but
whether it is
whether
based upon some
yes, ma'am.
records.
that information is not in the report, my lord.
And there is a specific order being passed, Mr. B. Kaushik, so and so is directed to obtain instruction in that regard. What is the instructions on as to whether the certificate which was issued,
Yes, ma'am.
was it on the basis of some records?
In fact, my lord, though I have received the instruction, that part is absent here, my lord. Whether it, in fact, they have
These
submitted.
are matters of 2016.
Yes, I understand, my lord.
First of all, this matter has come up before this bench.
My lord, may take up a two also, my lord, so that I can telephonically take the call whether the report was issued on the basis of a.
Otherwise, this is a bench two matter.
Yes, my lord, otherwise bench to matter.
That is why I was shocked to see Mr. Khatania here. Two options,
Yes, my lord.
whether this court should take up or not.
should take up, my lord. That is my humble prayer.
Then you get your instructions by two.
Yes, my lord.
As to whether the
ma'am.
certificate which was issued was based upon some records. If it is record, then I can direct them to consider.
Yes, my
If
lord.
there is no records, nothing.
Oblige, Lord.
Oblige.
Item 5.
Yes,
So this petition is for unauthorized construction of the respondent number 5, who is the neighbor of the my lord petitioner. We file a complaint that the private respondent constructed the house unauthorizedly and in danger of our boundary.
so
As per
why are you not filing civil suit? Why should this court under 226 look into as to whether it is in your boundary or not? That is none of the business even of the other respondents. Who are the other respondents?
I am appearing for resolution number 5 minutes.
It's okay. It is not the business of this Nagaon, the development or the deputy commissioner to look into it. If it is absolutely, it's a civil
Civil
dispute.
dispute. my lord.
My lord,
And if it is a civil dispute, go and file a suit.
my lord, that is,
Get a
they are not encroach our boundary by the construction, my lord. But they, when they construct the upper, my lord, then they.
Get an injunction before the trial court,
Can you see, my lord, page 84 of the.
whatever may be. But why should this court in between you and him involve him? There's no business out there for Mr. Count to be disturbed.
May I submit?
Isn't it, Mr. Count? You would obviously love to appear in the court. It's a different thing. But that doesn't mean that one should disturb you.
Matter is very simple, my lord. Matter is very simple, but they have made it complicated. First thing is this, his client, that is private restaurant number 5, has completed his ground floor, construction of ground floor with the permission of development authority and under supervision of development authority. After completion of this, the respondent number 5 started the construction of first floor. Then petitioner lodged a complaint before the municipal. I am for municipal, for respondent number 3, lodged a complaint that construction has been illegal. After receiving that complaint, inquiry was made through one of its junior engineer, and junior engineer inquired the matter and submitted report stating that yes, without permission, the first floor has been, construction of first floor has been started. Then after receiving that report, the board, respondent number 3, already issued a notice to the private respondent to stop immediately the construction as it is illegal, as because you have constructed without permission. Thereafter, the private respondent stopped the construction. Now, thereafter, they have filed this writ petition.
For demolition.
And our thing is this, under section 171 of the municipal act, without sanction of the board, nobody can make any construction, any sort of construction.
Now, if they construct, what do you do?
Then definitely we will take legal action.
Take illegal action.
That is- We will not allow it. We will not allow it.
No,
to
that
make-
is absolutely within them. You have any problem, you file a suit. But
Exactly,
but it
exactly.
shall not stop them from taking any legal action if it is permissible under the law.
Municipality has issued notice, accordingly, we have stopped it.
Understood, but you have made the construction.
Construction, in fact.
If the law permits them to demolish, they will demolish.
Only thing is that I applied for passport construction.
Construction fits around.
I'm not going to. How is it affecting you?
It's the waterfall from the wall, my lord, is in our boundary, my lord.
Understood. If it is, then it is purely a civil dispute. Whether it falls in your boundary or not, but that has to be looked into as to which portion of the land. As that land, whether that particular portion of the land falls in your boundary or not. He may say that no, he is constructed in his own land. You may say that no, I am constructing, he is constructing in your land. This is for the civil court to decide. Why should this court at all say? And if they have issued any proceedings out there for stopping, they will be at liberty to do so. And that is your prayer. May
Madam.
that there's constructing of the two-story RCC on the boundary line of the petitioner and so on. As regards the boundary line of the petitioner, this neither the Nagaon Development Authority, neither the Deputy Commissioner can do anything. It is for you to move the civil court and get a decree that this is the area where it is. That's nothing more than that. The instant petition has been filed by the petitioner seeking a direction upon the respondents to restrain the respondent number 5 from constructing a two-storied RCC building house on the boundary line of the petitioner land and to demolish the already constructed portion of the house. The facts involved here is that the land of the respondent number 5 is situated on the southern side of the petitioner's land. It is the allegation of the petitioner that for the purpose of constructing an RCC building, it is the requirement as per the provisions of law that a minimum 3 feet space has to be kept as an open setback, open space as side setback. However, the respondent number 5 have constructed the building by keeping only 1 feet towards the petitioner and thereby causing havoc and panic to the petitioner. It is under such circumstances that the petitioner had approached the Nagaon Municipal Board on 3/2/2017 to restrain the respondent number 5 from constructing the said house on the boundary line of the petitioner's land and also to demolish the already constructed portion. As no action has been taken, the petitioner has approached this court by filing the instant writ petition. Mr. S. Count, appearing on behalf of the Nagaon Municipal Board, submits that the petitioner has constructed the ground floor after taking the due permission from the Nagaon Development Authority.
Respondent number 4.
That is the respondent number 4. However, the petitioner thereupon raised the first floor over the said in the said RCC construction and receiving a complaint from the petitioner, there has been a notice has already been issued to the respondent number 5 to stop construction. And accordingly, the construction has been stopped by the respondent number 5. The learned counsel, Mr. S. Count, further submitted that if any construction is made without taking the approval from the Nagaon Development Authority,
Nagaon Municipal Board.
Nagaon Municipal Board, the said construction would be illegal and the said board would have the power, has the power to demolish if any illegal construction so carried out at the cost of the Mr. So-and-so, the learned counsel appearing on behalf of the respondent number 5 submits that the construction so carried out by the petitioner on the ground floor is within the permissible limits and in the land of the respondent number 5. There has been no violation to the building bylaws, to the permission so granted in respect to the ground floor. As regards the first floor, it has been submitted that the respondent number 5, upon receipt of the notice from the Nagaon Municipal Board, have stopped construction. Upon hearing the learned counsel for the party, it shows that there is a dispute as regards whether the petitioner, whether there is a construction, whether the construction so made by the petitioner, by the respondent number 5, falls on the boundary line of the petitioner. These are aspects which can be dealt with by the civil court or even by the Nagaon Development Board,
Nagaon Municipal Board.
Nagaon Municipal Board. As regards any violations so committed to the permission. So taking into account the above, this court finds no reason for interference in exercise of the jurisdiction under Article 2 to 6 of the Constitution. However, this court observes that the Nagaon Municipal Board as well as the Nagaon Development Authority shall duly take note of as to whether the respondent number 5 have made the construction in terms with the permission, and if not done, then shall take such action as necessary in terms with the provisions of the Assam Municipal Act 1956, read with, you have a bylaw?
Building bylaws.
As well as the building bylaws framed therein under.
Public.
Fine.
You got more than that.
Bibliography.
Yes, Mr. Dekar.
But after the last affidavit, my lord, the issue has become very small.
Six.
And they in that judgment, Poran, what is that name? Forgot it. That judgment, bank guarantee.
My lord,
You got a copy?
no, my lord. Pull in, I think.
I've inserted 2-3 judgments on how, when bank guarantee is to be done. After writing the judgment for 40 paragraphs, I thought that, okay, let me make it look better. Yes, tell me.
So, my lord, here the facts are like this, my lord. The bank, my lord, the UCO Bank had taken action under the SARFAESI Act. So there were certain properties which were attached. So we approached the DRT. Then we filed an application that let these properties be put to rent. And the amount be deposited in the DRT. So, my lord, the registrar took possession of the properties, put it to rent. Ultimately, the matter was compromised, and whatever rent was collected, my lord, that was adjusted against the final thing. There is no dispute on that. Now, we made a calculation that the amount of rent which was adjusted should be more. The amount actually received was more than what was actually adjusted. So we filed an application before the registrar. The matter was put up before the PO. We filed an application. Our application was rejected. Then we came up before your lordships, my lord. Now, in the last affidavit dated 26/6, my lord, in paragraph 11 of the affidavit, they are saying that 1,75,000 and odd rupees is deposited. My lord.
Where? Paragraph?
Page 123, running page, para 11, my lord.
Yes, you got the running page. Yes.
Para 11, my lord. That in view of the facts and circumstances stated herein above, it is submitted that the amount as stated above was deposited in the account of the receiver. Mrs. So-and-so reconstruction has paid rupees so-and-so in compliance with the order of the Honorable DRT. An amount of rupees 1,75,000 and odd is still lying in the account, which was credited by the bank after the payment of so-and-so. And the same may be released as per the directions of this one.
So you want that money back?
Let if the money is given.
Really?
Only he will furnish the bank details so that.
Within a week, I'll find.
You are paying for whom? Money is with whom?
Money is in the DRT.
You are paying for whom? The instant writ petition has been filed.
The order under challenge is 28/3/2017, madam.
Challenging the order dated 28/3/2017 passed by the learned DRT in MA number 25/2017 arising out of SA number 02/2006. From the materials on record, it reveals that the UCO Bank, is he a party?
Not here, madam. Ultimately,
That UCO Bank had initiated action under section 13(4) of the Securitization and Reconstruction of Financial Assets and Enforcement of the Security Interest Act 2002, for short, the Act of 2002, against the petitioners and the guarantors. Under such circumstances, the petitioners approached the Debt Recovery Tribunal, Guwahati, under section 17 of the said Act of 2002. The said application so filed was registered and numbered as SA number 02/06. It is further relevant, from the record, further seen from the records that during the pendency of the said proceedings under section 17 of the Act of 2002, an application was filed by the petitioners that the attached properties be directed to be put on rent and the rent be deposited in an interest-bearing no-lien account. It further transpires that the said, it's a loan, it's taken as a loan, or what is mentioned as a loan. The said
If it was taken over, my lord, there is a provision in the securitization. right?
It is not, it is given to you, na? The, what, there's a
Maybe it's
specific,
actionable claim is sold, my lord.
no, there's a term used out there, na, in the
It's a
Surface Act.
reconstruction company. It's a reconstruction company.
No,
which
it is
gives
given per reconstruct. What is being given? It's not said to be the loan.
The loan is not given, my lord.
The security says.
Securities.
It is further relevant to take note of that in the meantime, the secured assets were taken over by the securitization company, namely MSJM Financial Reconstruction Company Private Limited. And in the year 2014, the matter was compromised at rupees 5.9 crores. Out of which the amount of rent collected was adjusted against the aforementioned compromised amount, and the petitioner was to pay the balance. It is the case of the petitioners that in the said compromise petition, there was no mention of the amount of rent, as the parties were not aware of the exact amount. But in the order dated 23/2014 passed by the DRT, recording the compromise and closing the proceedings, it was recorded that the sale amount was rupees 1.30 crores. It is the further case of the petitioners that at that relevant point of time, that is on 6/9/2014, the amount was rupees 1,45,71,257. It is under such circumstances, an application was filed that, taking into account that the entire compromise amount has been already paid, an amount of rupees 25,23,743 was still lying in the
With the DRT money.
with the DRT. However, the said application was registered and numbered as MA number
25.
MA number 25/2017. However, the said application was rejected by the order dated 28/3/2017, for which the instant petition has been filed. It appears from the records that notice was issued by this court on 24/5/2017. Further, from the records, it reveals that there has been an affidavit filed by the respondent number 3 on 14/11/2022. Be that as it may, an additional affidavit was filed by the respondent number 3 on 27/6/2023. In the said affidavit at paragraph number 11, it was specifically stated in the said affidavit filed by the register Debt Recovery Tribunal Guwahati bench. It has been mentioned at paragraph number 11 that MSJM Financial Assets Reconstruction Company Limited has been paid rupees 1,45,71,257 in compliance to the order of the DRT. However, an amount of rupees 1,75,384.72 is still lying in the account, which was credited by the bank after the payment of rupees 1,45,71,257, and the same may be released as per the direction of this court. taking into account that the said amount belongs to the petitioner. And the DRT cannot be permitted to hold to the said amount. This court therefore directs the respondent number 3, that is the registered DRT, to forthwith and not later than 15 days from the date a certified copy of the instant order is served upon the petitioner, upon the respondent number 3, to disburse the amount of rupees 1,75,384.72 to the petitioner. Full stop. This court further directs the petitioner to submit the bank details along with the certified copy of the instant order. Petitions on this.
7.
Yes, Mr. Ahmed,
My lord,
what is this?
in this case, my lord, originally notice was issued to vacate 2.5 acres of land.
Hmm.
After receiving notice, we already abandoned that part of land. Now, the authority come and say that you also keep vacant 9 foot of your parcel.
Huh?
9 feet from that land to our parcel land. That is why I come here.
You are concerned with where is the notice?
Notice is, my lord.
Page 24?
Yes, my lord.
Whereas it has come to the knowledge from the report of the subject that you have occupied an area of government land. This is the order you are referring to?
This is the page 17 law of California.
Page 24? Which law, which order?
Yes, page 17, we all are notice, my lord.
Huh?
Page 2, it is also notice.
How many petitioners?
5 pages.
Court fee? Court fee?
The same cause of action, my lord.
You choose one of them. Everybody has a different so-called notice.
I will pick.
Yes.
Ah,
Now,
sorry,
tell.
I'll pick. The only that
That is the big problem. That day I was finding out one matter. This is regarding compensation. One person happens to be another person in respect to another case, and one person happens to be another person in respect to another case. Both are filed in one petition seeking a direction that they be paid compensation. Now, how do you do it?
I'll pay. So that area of land I already abandoned, my lord. Then now they want our parcel land, my lord. That is why you come here. They all go-
Mr. Ahmed, kindly tell me one thing. Show me the impugned notices.
Yes.
First of all, you have not challenged the impugned notices.
No, I am not saying.
Fantastic. Now, show me where is the impugned notices. Are you saying from page 19 onwards? Okay. Now, see the schedule which is being given. Dark number Kisam 744,
Area 1.5 lesser.
half lesser.
Half lesser.
Half lesser. Half lesser will be 72 square feet. Next one, half lesser.
Half lesser.
Now, are you saying that this 74 dark number is yours?
No.
Then-
This is God land.
Then what is your problem?
Then I will, I already remove it, my lord.
Dude, but where these lands are. if-
Adjacent power land.
Ahmed, this court will only direct the authority to take action in terms with the notice. Nothing more.
Nothing more, my lord. My lord.
In
That-
fact, my lord, in para 9, my lord, they
I
have,
also
para
mentioned.
9 of the writ petition, they have mentioned regarding that 9 feet to vacate the 9 feet land from their own land, my lord.
Understood.
Yes,
See,
yes,
you can't evict them from
No,
their land.
That is
You are saying
without
744.
you flowing.
He says that
that cannot
744,
be.
I am not there. You find out if he's there in 744, throw him out. If he's not there,
Right.
then nothing is there,
My lord.
isn't it? Para?
Only our.
Para 9 of the
8 and 9.
petition they have mentioned.
You throw him out if he is there in 744. And the land which have been allotted to the petitioner is what? What is your number of your land?
Our pattern number, my lord,
Is 697.
697 and 349.
349 is the patta.
Patta.
Dark number is
Was
697.
9/7, my
So
lord.
you are the owners of 697. And there they cannot. But if it is in 744, you will throw you out.
Oh, half lesser. We already abandoned that. We already
remove that, my lord, fencing.
But the authorities will decide. There's nothing else. The instant writ petition has been filed by the petitioners, who are 5 in number. Challenging the action of the respondent authorities in trying to evict the petitioners from their plot of land covered by dark number 697 or patta number 349 of village Needs Mikirgaon, PS Mikirbheta in the district of Morigaon, Assam. This court have duly perused Annexure 1 to the writ petition, which is the Jamabandi, in respect to the said land. In respect to the land covered by dark number 697 of patta number 349 of village Hetu. From a perusal of the said Jamabandi, it reveals that the names of the petitioner are mentioned therein. Are it? Is it?
Yes.
It further reveals from Annexure 2 that the pattas in respect to the said land covered by dark number patta number 349 have also paid their revenue. Be it as it may, each of the petitioners have been issued show cause notice under Rule 18(2) of the settlement rules framed under the Assam Land and Revenue Regulation 1886. In the said notices, eviction notices, it is seen that the schedule has been duly mentioned to be at village Needs Mikirgaon, Moza, Silpukuri, dark number Kisam -744, area half lesser. Full-stop. The learned counsel for the petitioner duly admits that the petitioners have no right over dark number Kisam 744, which is a government land. Taking into account the above, this court therefore disposes of the instant writ petition, directing the respondent authorities not to evict the petitioners. Not to evict the petitioners. In respect to the lands covered by dark number 697 of KP Patta number 349, in village so and so. It is, however, made clear that the above directions shall not in any manner be construed as shall not be evicted from so and so. However, taking into account that the petitioners have no right over dark number Kisam 744, the respondent authorities, more particularly the SDO what? SDO?
This circle officer.
Circle officer, deputy commissioner and circle officer made part in it.
And shall not, however, it is mentioned that taking into account that the petitioners have no right over dark number 744,
Land measuring half plus.
which is, you don't have any right over 744. Dark number 744. The respondents, more particularly the respondent number 4 and 6, shall be at liberty to take such action as deemed necessary in accordance with law.
Okay.
Hello.
Interim order, if any, stands vacated. It. Yes, what are you asking for?
My lord, this matter relating to my lord kidnapping of my husband, my lord.
Kidnapping of?
My husband, my lord. A status report has been filed, my lord.
And in respect of which Lanka PS case number you have? Has the charge sheet been filed?
Yes, madam. I have got the information. Charge sheet has already been filed on 28/5/2023.
Show me,
And a copy is not available. It's a
Then
verbal instruction.
get it at 2 o'clock.
Okay.
Get the charge sheet.
No.
So you can very well ask these people now. When was it filed?
28/5/2022.
22. Now these are all electronic. So you get them, just produce a copy of it.
Nine.
Made legal.
Yes.
Here in the 226 application, I have challenged the complaint case and the proceeding filed by the respondent number 2, alleging that the wife and her family has cheated the husband and went for a marriage, the arranged marriage. And my lord, the court took cognizance under section 417, which was under challenge before this court. My lord, there was a stay order on this
You are asking for quashing of a
complaint case.
complaint case under section so and so.
So.
And suspension of the order dated 3/6/2000 pending before the court of the judicial magistrate.
My lord.
The why?
Because my lord, there was no case of, because their allegation is basically that the wife is a third gender. And for that, my lord, there was an order from this,
Where is the complaint case?
my lord, complaint case in that page, it starts at
33.
page 33, it starts at page 33.
What is that complaint case? 120-417-294-506. The accused number 1 is the wife of the complainant. Accused number 2, 3, and 4 are the father-in-law, brother-in-law, and sister-in-law of the complainant. Accused jointly hence a complete to solemnize the marriage of the respondent number 1 with the complainant. Accordingly, on instigation of the
What to do, my lord? This
My
is-
lord, if your lordship permits me one thing, my lord.
Mr. Vishwas, no case. You file all whatever you.
My lord, if your lordship permits me, there was a medical board and test of because of this honorable court's direction. And the report has come
That is
from the
before your
medical
lordship.
board.
my
The
medical
report says that she is a normal female and she is not of a third gender. This is what the medical report after the judicial order was passed from this court for a testing of the female. Because their allegation was that she is third gender in their eyes.
Suspected to be third gender, we say.
She is a normal female.
Okay, but if you have any case, it's maybe a case of nullity, you do whatever you
Yeah,
like,
yeah,
but
fine.
what is all this thing?
You file for nullity of marriage.
Eh?
We have also filed before the family court.
Very well, proceed with that. What is all these things? Nothing out there. I'll file a criminal case for that. Who has filed? You.
No,
No,
but
we
they
have-
have filed
we have
for
filed,
the wife, the father-in-law.
Go for a nullity. They
Nullity
know.
also we have filed. I have annexed here. They have annexed.
Fantastic. Very nice. You have filed a nullity, but there's no, this type of, this has no case out there. You are saying that all this case is pertaining to that she was, she never have had any periods prior to that.
Yes, never, till today.
Understood, but whether it may be at best a case of, somebody must have said so. But would it be a case of criminal proceedings?
But
She got married to you.
everybody, when marriage took place, my lord, they
You
they have
wanted to,
separate of this
you,
thing.
you had no problem. You wanted to take her to the hospital also, to the
She
doctor.
never want to go.
Understood.
This
She-
time, because of the honorable
Understood.
court's order, she was compelled to go to medical college.
But she never wanted to go. But whatever way, you wanted to take her to the hospital for treatment, meaning that you had
But
good.
unless she cooperated with me for treatment, how can I take her?
No,
That is
but-
the problem.
But she didn't go, it's a different thing. But can that be a case of a criminal proceeding?
Well, my lord,
You
nobody,
you didn't have a problem till then. As regards, what do you call, taking her to the hospital. Wanted to take her to the hospital, but she didn't go. It's a different. Till there, you had no problem in the FIR.
my lord, we had no other option. The nullity we have filed, my lord, because you see, everybody, when marriage took place, my lord, it was big hope that there will be happiness in the life. But what I got in my life, you see, that is to be also seen on the other legal matter.
Understood.
Such a
Maybe,
suppression of
but-
the fact, my lord.
But does it mean that you are going to put somebody behind the bars and you
No, no,
have the
my lord, I have
soldiers
filed a
out there?
complaint against her.
Wouldn't that be
But
a
the-
case of a vengeance or a vexatious litigations out there?
And the my lord,
I
again,
don't understand. Yes, nullity, you may have a very good case out there.
nullity I have
What is
also
all
filed,
this
my
thing?
lord. already.
I'll push it. Nothing out there. Quash it without saying that this would, the quashing out here will have any impact on your,
Other
Petition of
thing.
nullity, yes, yes.
My lord, my lord. My lord.
anything more?
No, my lord.
The instant with petition has been filed challenging for quashing of the complaint case number. Complaint case bearing CR case number 1963/2016. Registered under section
Page 50,
where
page 50.
417. Public 34.
in respect of which, registered no, in respect of which cognizance was taken under section 417/34 of the Indian Penal Code by an order dated 3/6/2017 by the Court of the Judicial Magistrate. What is this? What court is? Judicial Magistrate First
Kamrup.
Class,
Kamrup.
Kamrup Metro at Guwahati. The complaint case, the complaint petition, petition being CR case number 1963 Uporothuru Sieta oblique 2016 has been enclosed as annexure 4 to the writ petition. From a perusal of the said complaint petition, it transpires that it has been alleged that the accused number 1 the complainant married the accused number 1. At the time of prior to the marriage, there was no disclosure. By the accused number 3 and 4. That the accused number 1 did not have her menstruation in her lifetime. Full stop. It has been further alleged that the age of the accused number 1 to be 29 years
Yeah.
was also not disclosed to the complainant. Thereupon, the marriage took place on 25/2015. It further reveals from the said complaint that the accused number 1 did not permit the complainant to cohabit with her. It further reveals that the complainant thereupon, taking into account that the accused number 1 did not have her menstruation in her lifetime, wanted to take the accused number 1 to the doctor, which she refused. And all of a sudden, she left to her parental house. It further revealed that the accused number 1 was 36 years old, and this aspect of the matter was not informed to the complainant. It is under such circumstances that the instant complaint was filed. Before the court of the Chief Judicial Magistrate, Kamrup Metro at Guwahati, for issuing process against the accused persons. And thereupon, to punish them upon being held guilty. This court finds it relevant also to take note of from the complaint petition that it is an admitted fact that on 25/2015, the marriage was solemnized. The instant petition was filed. No, the state complaint petition was filed in the year 2016. And in the said affidavit, the age of the complainant was mentioned as 47 years. This court further finds it relevant to take note of the order passed by this court on 13/12/2021, whereby the superintendent Chief Superintendent Guwahati Medical College and Hospital was directed to constitute a medical board comprising of appropriate medical experts so as to examine the accused number one, that is the petitioner number one herein, and submit a report regarding the determination of the gender of the petitioner number one. It further reveals from the records that on 14/10/2022, the Director of Medical Education has submitted an investigation report the contents of the medical report from the same medical report, it reveals that after carrying out the clinical examinations, sonography of the whole abdomen, hormone reports and chromosomal SCYTO cytogenetic report, it was evident that the petitioner number one the accused number one was a normal female of perimenopausal age group. Next. This court also finds relevant to take note of that the Judicial Magistrate First Class, by an order dated 3/6/2017, after considering the statements of the accused, of the witnesses, and the reports were submitted under Section 202 from the Dispur Police Station, found sufficient grounds for proceeding against the petitioners herein who were the accused 1, 2, 3, and 4 in the complaint proceedings under section 417/34 of the Indian Penal Code, and accordingly issued summons. This court have duly taken note of the respective submissions, as well as also perused the complaint. This court finds it relevant to refer to a judgment of the Supreme Court in the case of the state of Andhra Pradesh versus Golconda Lingaswamy, reported in 2004, 6 SCC 522, and more particularly to paragraph number 5, 6, and 7. From the above quoted paragraph, which is quoted here in below. From a above quoted paragraph, and more particularly the reference so given by the Supreme Court to the judgment in the case of R.P. Kapoor versus State of Punjab, reported in AIR 1960, SC 866. It was observed that where the allegations in the first information report or the complaint taken at its face value and accepted in its entirety do not constitute an offense, this court under Article under Article 2 to 6 of the Constitution or under Section 482 of the Code of Criminal Procedure 1973 can interfere, can quash the proceedings. This court further finds it relevant that in R.P. Kapoor, Supra, it was also observed that where the allegations do constitute an offense, but there is no legal evidence adduced or evidence adduced clearly or manifestly fails to prove the charge, it may be a case where there can be an exercise of jurisdiction under Article 2 to 6 oblique of the Constitution, oblique Section 482 of the Code. The Supreme Court in the case of Golconda Lingaswamy observed in paragraph number 7, as quoted here in above, that it is important to bear in mind the distinction between a case where there is no legal evidence or where there is evidence which is clearly inconsistent with the accusations made, and a case where there is a legal evidence which on appreciation may or may not support the accusation. It was further observed that the High Court in such circumstances, while exercising the jurisdiction under Section 482 of the Code, would not ordinarily embark upon an inquiry whether the evidence in question is reliable or not, or whether on a reasonable appreciation of acquisitions would not be sustained. That is, that a function of the trial judge. It was further observed that the judicial process, no doubt, should not be an instrument of oppression or needless harassment. And the court should be circumspect and judicious in exercising the discretion and should take all relevant facts and circumstances into consideration before issuing process lest it would be an instrument in the hands of a private complainant to unleash vendetta to harass any person needlessly. This court further finds it relevant to take note of another judgment of the Supreme Court in the case of Mahmood Ali and others versus the state of UP and others, reported in 2023 SCC Online SC 950, wherein the Supreme Court observed at paragraph number 13 that the court, while exercising its jurisdiction under Section 482 of the Code or Article 226 of the Constitution, need not restrict itself only to the stage of case, but is empowered to take into account the overall circumstances leading to the initiation, public registration of the case, as well as the materials collected in course of the investigation. Paragraph number 13 of the said judgment, being relevant, is quoted herein below. In the backdrop of the above law, as submitted, as mentioned herein above, and taking into account the application so far and the complaint, it is the opinion of this court that the said that the accusations so made may be a case for seeking nullity of the marriage in terms with the provisions of the Hindu Marriage Act 1955.
Yes, 1955.
But however, there is no case made out under the provisions of Section 417/34 of the Indian Penal Code. More so, taking into account the medical report so submitted by the medical board. Accordingly, this court therefore quashes the complaint case number so-and-so, as well as the order, as well as sets aside the order dated so-and-so passed by the judicial magistrate. On the basis, in view of the above, the petition stands disposed. It is made clear that the observations made herein shall not affect any proceed, is limited only to the complaint case, or is limited only as to whether a case has been made out under Section 417/34 of the Code or of the Indian Penal Code against the petitioner's hearing. The same, however, shall not affect the observations herein above shall not in any manner affect the proceedings so initiated by the respondent
Yes.
in the
In abstract civil case number 838/2016,
pending before.
before the family court, Kamrup Guwahati, Principal Judge Family Court. My lord, may I be permitted to have a copy of the medical report?
Yes, is it there?
Yes, I have.
Are you giving it?
Yes.
You are only giving not only that. Give the other copies. Where are the other copies?
I'll get it photocopy.
No. See, madam, can you read the medical report? That is why I did not quote. See the medical report. See the next page. There are various enclosures to the report. Where are those?
Semi-menopausal phase.
You have to give those.
Lordship.
You file it in the court.
Lordship.
Miss MS, before parting, this court duly take note of that submission of Miss S. Sharma appearing on behalf of the Health Department, that the complete set of the medical report shall be filed before the registry of the court, which shall be kept on record
Lordship.
within 10 days.
Lordship.
Yes, madam.
But I take the liberty to mention that one item 41 to 45, my lord. I have to withdraw the cases, my lord. the railway decided to make payment of the 50% balance amount, my lord. 41 to 45.
Forty-one to forty-five, you are withdrawing.
Yes, my lord, I am withdrawing on the, I have received the instruction from the railway. They have decided to make payment of the balance fixed amount.
When?
My date is not mentioned, but they will pay.
We'll take it up at 2. Yes, let's.
Can you be allowed to mention an item, my lord? Order item 46, it has not listed for last 3 occasions, my lord. Today is also no possibility of reaching, my lord.
What?
Today is also not possibility of reaching, my lord.
Why?
It is for item 46, my lord.
46 it will reach. Don't worry.
Over, it is a matter of admission, my lord. Wrongly looks at in order.
Okay, we'll take it up for admission. Don't worry. Now, we'll take it now. First, let me take her matter. The first matter.
41 to 45.
Yes, my, I have received instruction, they will pay the balance digital amount. To all the,
They paid.
no, not pay, they will pay.
When?
When already I obtained instruction from them, and I asked them when they are going to pay. They said it will take 3 months' time for following the departmental proceedings. Within 3 months, they will pay.
These are all against one award.
Yes, common judgment and award dated 9/8/2005. Passed in misreference case number 2496 up to 34 to 96. In other cases, already money execution order has been passed. They filed their respondent filed money execution cases and execution order has been passed, and the railway already preferred appeal with CRP against the execution order. This was not entered by the honorable court. So, my lord, that's why railway decided to make payment of this digital amount.
If you, बाकी kita anybody? That's it. 41 to 45. The instant appeal arises out of the judgment and award dated 9/8/2005, passed by the learned ad hoc additional district judge number 3, Kamrup Metro at Guwahati, in misreference case number 24/1996. Whereby it was decreed that the value of the land, market value of the land, would be rupees 80,000 per katha. Of the acquired land would be rupees 80,000 per katha. And the petitioner would be, and the claimant would be entitled to the enhanced compensation along with interest and additional sum. Mrs. U. Chakraborty, the learned counsel appearing on behalf of the appellant, submits on instructions that the appellant, that is the Northeast Frontier Railway, would not like to press the instant appeal. In that view of the matter, the instant appeal stands dismissed on withdrawal. LCR, I say? What? The registry is therefore directed to forthwith return the LCR to the court below.
My lord, in item number 41, there is three interlocutory applications for substitution of the legal heirs of the appellant and the sitting aside abatement and the punishment delay. This three petition may be closed.
You are withdrawing it.
Just one.
You are withdrawing it, which means same order. Khali a reference case bodli bodi. One is this is 24 asil. Could take that a beleg hobo sab. Take it a silo. I have not got the file. Oh, file hobo,
Well,
khali,
item
reference.
number is not 24, my lord. In item number 41, the
LA,
reference case-
LA appeal number 1 of 2015.
Yes, my lord.
What is it
Reference
is
case is the 28 of 1996.
882 Pihoro against the appeal is against directed against. Why? How do you say that?
When as per the judgment, my lord.
No,
judgment
which this just for example, LA appeal number 1 of 2005, 15.
15. Is it
Common judgment and order in so and so. Now this is in reference to which appeal?
minus this reference case number 28 of 1996.
How do you know that?
Well, it's from the judgment, my lord.
Where is it?
Judgment is the page number 8, my lord,
Page number 7.
7, my lord. And
So
the judgment,
there are this judgment has various appeals.
yes, my lord.
Then
We have challenged the various appeals, my lord, because there is a different reference cases. So there is
reference case.
individual
So
applications.
we are concerned in this appeal, which reference case?
28 of, in item number 41.
This is 28.
It
Itu item number, itu
28 to
LA
96.
appeal number, itu kot pabo na page 22 pabo. Page 22 of the appeal memo pabo. Miss reference case number 28/96. Huh? Interlocutory applications was so close to you.
About my giving it a time, my lord, time bound.
Huh?
About fishing a time, my lord, for making payment, my lord. But that will.
Within 3 months, they will pay. my lord.
Madam, Mr. Das, I am not saying about time.
My lord.
The reason why I'm not saying about time is, if I say the time, then within this period, they may not pay the interest. That is why, but your interests would be as per 28 and 34,
My lord,
which will accrue, keep on accruing.
my lord.
So if I
Till the-
give
till the
them
date of
any
payment,
time,
My lord.
meaning thereby they will tomorrow say the High Court had given us this amount of time and as such we should not pay this interest for this amount. That is the reason why. Otherwise I would have exceeded out there, say that 3 months they will pay.
Right.
You know what to do.
Obliged, my lord.
Obliged you.
Timing item number 8.
My lord, in this case, that concern. Yes, charge sheet is yet to be placed before court, my lord, so I could not get the information through electronic media, my lord. So it is still pending in GR office, my lord.
Is it?
It is still pending in the GR court, my lord.
Where?
It's a Chief Judicial Magistrate, Ojai. Not yet placed before court, my lord.
So
Or
charge sheet has not been filed.
charge sheet has been filed. It is submitted for submission before the honorable court, my lord, but it is not yet submitted, my lord, by the office.
What is this not submitted before the office? Have
GR
you filed the
branch-
charge sheet or not?
Yes, my lord, that it is.
If you
before
have
GR
filed the
branch.
charge sheet, has the court taken cognizance of the charge
No,
sheet
my
or
lord,
not?
not yet.
Why? When did you file?
My lord, as per my information, it was sent from SP office on 28/5, my lord. It's a charge sheet number 12022, dated 28/5/2022, my lord.
23,
22, charge sheet
22.
number,
To which court?
to CGM Hojai, my lord.
CGM Huzai.
Yes,
The learned counsel for the learned counsel for the respondents submits that in respect to Lanka PS case number 583/14, registered under section 328/365/34 of the Indian Penal Code, a charge sheet has already been submitted before the court of the Chief Judicial Magistrate Hozai on
28/5/2022.
28/5/2022, bearing charge sheet number
120 CS 120/22.
So and so. Full stop. The registry is directed to inquire in the office of the inquire with the office of the Chief Judicial Magistrate Hosai as to whether the said court have proceeded upon the said charge sheet filed, the above mentions charge sheet filed. And if not, why? List the matter again on 11th of September.
Obliged.
Timing at 10:04.
Lordship, I had inquired your lordship. I had a talk with the headmistress also. Lordship, what they are saying is that now there are no records.
I know that. That is why.
No records.
Now, on what basis did he file this? Say that this thing that she was working out there from 2001 to 20. He couldn't have done that.
Lordship.
This document is something wrong with this, and this person must have, whoever was the headmistress is no longer there.
She is not there. In fact, she has expired, your lordship.
Yeah, it have expired.
Lordship.
So if there's no records on the basis of this, can you, on the basis of this, say that this document can be the basis for counting you that you were in service for those 2 years, if there's no records?
Obviously, the authorities did not consider my case because there were no.
But there is no records.
Yes, this was placed. This was not
No,
considered.
this document is there, but can these documents, which is, because the authorities did not find anything.
And my lord, there is a report by the headmaster who was the successor to this principal.
Hmm.
Now, he in his report said that there the attendance registers were not there. But he did not in the report also, except for the fact that he said that there was
Did you receive any salary during that period?
during which period?
This period from 91 to 93.
Yes.
So where is those salary receipts? If you have got some salary, wouldn't that be also a reason to show something is there? Maybe the attendance register may not be there, but there will be a salary. Only requirement is whether you were working for those 2 years.
Stage was a venture stage. The stage at that time was a venture stage. It was not a provincialized school then.
Whatever may be, whether there will be documents as regards the salary being paid to you. If there was a salary being paid to you for those 2 years, they will have the record. They may not have the records of the attendance, but they may have the records of payment of salary.
Lordship, there are no records now because in the last year there was a flood. There was a big flood. So in that, all the records had gone. That's what they have stated, your lordship.
My lord, at least from my side, if I can come up with an affidavit showing that I had received salary with any document, if provided there is any document.
How the salary used to be paid? Cash?
I have to take it.
Obviously, 91, 92, we are concerned.
It's a lump sum paid to be fixed by the managing committee, your lordship. That's what.
So that managing committee then must have given you an appointment order.
Yes, appointment order is annexed out.
Now, thereafter, did you get your salary? That is the most important thing.
Salary for the non-provincialized period was received. That obviously was received by the other staff also. That is what my instruction that has been. But after provincialization, obviously, now that I know that she is obviously no longer associated with the school, that her service is no longer taken into acceptance. So
Because the one-time exercise is all long over. The one-time exercise finished around 2005-06. We are in 2023.
here, my lord, this exercise in regard to the case of the petitioner, this was carried out in the year 2015 though. Because-
Understood, but
Yes,
that was done. It was a more of an extended.
yes.
But otherwise, it is not so because the entire one-time exercise finished around 2007-08.
Immediately after Jivan Dekar.
As per Jivan Dekar, it has been done out there, and these people were mostly appointed after. There were some who were appointed prior to 1 to 2005, but rest of them were appointed after 1 to 2005, and most of them finished off, all appointments finished off around 2008. So now therefore, it will be another 15 years therefrom. It will be very difficult now for that particular person to again look into as to whether you have worked for these 2 years, and that too on the basis of a policy. You see, the regular provincialization then was made on the basis of on the basis of, it is not a case of provincialization, it is a case of regularization by which they were brought into the service. Now, whether the scheme still subsists, that is another aspect of the matter. Are you having the scheme? Which you will obviously say no. Then what to do? No case.
And even, my lord, the prayer that I am making regarding making an endeavor of bringing anything which would show that salary payment was made. Even then, even to that effect also, I have my doubts whether my client will be in a position to provide me with anything. But this.
It is more of a case of a regularization. The regularization scheme is long over. How can this court now direct? Because more particularly these regularizations which are being done is on this court can't direct. Although this court had directed at one point of time, but now after Uma Devi, the question of this court directing regularization does not arise. Yes, there might have been a case where these people have not taken into certain documents and thereby has arbitrarily deprived you of something. But for that, we need some document that there has been an arbitrariness on the basis. Now they say that there is no records from 1991 to 1993. And you can't substantiate anything on the basis, but a document of 2008, which I don't think would be the proper document for the purpose of doing.
So far the petition is concerned, she only has this document. Obviously, there is nothing else by which this case can be. So this is the only thing that the petitioner is relying on.
So what to do?
I leave it.
I think no, better off. Let me not dirty my hands and dismiss this petition. Let it go to the appropriate bench. You have some other judge may think, yes, something. Oh. The matter pertains to bench 2. However, it has been wrongly listed before this court. And as the court is not presently taking the said roster, this is the matter before the appropriate court.
All right, sure.
And number 10.
Yes.
My lord, here, the prisoner has filed a additional affidavit, my lord. Probably not before your lordship, the copy of it is there. My lord,
What is this additional affidavit?
yes, my lord, there was an order of this honorable court, interim order, my lord, that there is a, my lord, garbage that transport station, my lord, built in front of my land, commercial land, my lord, Nyadipatta. So, my lord, there was an order, document sheet.
Then,
At page,
but they are commissioning it.
yes, commissioner.
Where is this place?
Places in my lord, VIP road. My lord,
I have to apologize, man.
For what? For making a false, wrong.
Taking a wrong decision, my lord.
Huh?
So there is an interim order preventing him to take a leave from the court to who is commissioning that.
You have commission.
But in the meantime, my lord, it has been inaugurated and completed during that period and inaugurated on 31/1/2019. That had been because these transfer stations are serving 2 divisions, division number 4 and division number 5, and that transfer station, all the garbage from the primary collection care, thereafter it has been displaced to the transported.
How far is the distance from this petitioner to the garbage?
my lord, immediately in front.
No,
How much is the distance?
no.
I may say that you are immediately in my front with
Yes,
within
still
the
that-
distance of another 10 feet.
My lord,
But is it something like that?
I'm just 15-20 feet, my lord, I'll just find out, my lord. But
Across the road on the
across
side?
the road, my lord,
So the road is the VIP road?
VIP road,
So the road must be around minimum 30 feet?
not across the road, my lord, in the same side, my lord. But from my place to the road, my lord, there is some distance is there, but it is in front. Because I have annexed, my lord, that photograph, my lord. My lord, it is rendering my commercial.
You see this page 36
Yes.
of that photograph.
Yes,
See that? Nearby there is nothing.
my lord, the land just beside this particular station.
No, this particular property which you have enclosed as page 36,
Yes.
see? On the back, there are some sheds. See?
Place 36.
On the back, there are some sheds. Obviously, that's not your property. On the side, there is a road.
My lord, I have been told, my lord, immediately behind that particular station, my lord.
So there are some sheds. Is this the property you are saying? And in between, there is something empty.
Yes, my lord, there is something empty, like there is, must be a service road sort of thing. But that I have to just find out, my lord. But instruction is that immediately before my property, my lord, it's a commercial plot,
So
my lord.
if it is immediately before your property means it is across the road. Are you saying that it is across the road?
Not exactly across the same side, my lord,
Or are you saying that your property is on the road?
not in the road,
It's not on the side.
but
But if it is before, I will obviously the presumption will be that it is across the road.
not that way, my lord, just in, well, this is the road, my lord, in front of the road, in front of my property, my lord.
Understood. So if the road is the road in between your property and that property, the garbage center?
Road is not there, my lord, that the side of the road in my side, my lord. Road in my side. The road adjoining.
But from these thing,
Yes,
at
but
page
these-
36, it does not show anything. Where's your house? What property is that?
It is a vacant. Vacant land, my lord. Vacant land,
So on the back side is a vacant land.
yes.
On the side, there is a vacant land.
Page 24 of my petition, my lord.
That property today is also vacant.
Vacant, my lord, because it's a commercial, commercial land, my lord, and residential also at the same time. There are 3-4 properties, my lord. So immediately, since, my lord, this station is,
Yeah, something is there. Wait.
Yes.
Hindustan College. Petitioner's land existing. It's on the back. How far is this? You are in that, your land is that sheds. Are those the sheds out there in the?
maybe, my lord.
That means your land is empty.
Empty, otherwise empty, my lord. That is.
He's
I'm
admitting
submitting,
empty.
my lord.
So
No, my lord, it is, we cannot, because these things are there, my lord. We'll develop it in future, my lord. Maybe they might have developed by these years also. But before, for this, my lord,
as of now, it has not happened.
has not, because of.
Have you taken the permission?
No, my lord, not that.
Put it there. You see this document which is given here somewhere.
Yeah.
Your land is sold out there. That is a VIP road. Hindustan College is on that side. Hindustan Hostel is there. Car wash is there. And in between this, there's a 9-meter wide road. But your road, your building or your plot of land is on the back side of the existing garbage station,
Yes, backside,
which is empty.
which is empty. But my lord, it's a bigger plot of land, that there are projects, my lord. But for these, my lord, there would be 2 type of difficulties, my lord. One is my commercial things will be at stake. And second, my lord, for residential purposes, my lord, it's a big one, 100-meter by 20-meter. Big station, my lord. It will be otherwise also it will not be proper to reside there, my lord. That is what, my lord, because my lord, my right is some grossly affected, my lord. That is there, my lord. My lord, because I have also stated another 300-meter, my lord, there are government lands also. My lord, it can
That will again affect somebody else.
government land, my lord.
Now again, that will affect somebody else.
But
Nearby to that government land, there might be some other land.
it is there, my lord. But I have stated, my lord, 300-meter there are. It would be.
Now show me from this Ministry of Environment, Forest and Climate Change notification, which is, I think, your case. That within what area the garbage station should be? You have also made something at nearby Chandrapur, what is that, Sundarpur.
Yes, that is the garbage station.
It's just something similar to
Similar
that.
garbage station. There, we need
Sundarpur, that-
more garbage station, but we are limited. Garbage station, we have limited number of garbage station. We actually, from the houses, if tempo trucks, it goes there. There segregation takes place. From there, it is a main garbage station, that is landfill site, that is not Borga, it's a Bellor toll land near National Highway 37. There we, or recycle it. After its segregation from the transport station. Because in the absence of transport
No,
station,
is it the law that you cannot have a garbage station nearby a residential plot?
I have to check up on that, but there is a,
I have gone through it, but there is no actual proper things, my lord. But one place I have got from him only, my lord, copy H5, my lord. That is solid waste management rules 2016. It says the landfill site shall be 100 meter away from river, 200 meter from a pond, 500 to 200 meter from highways, habitations, public parks, and water supply wells, and 20 kilometer away from the airport. There's some yardstick, my lord, you will better
no,
know.
no, that is something different. This is landfill site.
Huh?
It is that Bellor toll area. That here it is a transfer station. We just bring the from the primary collection, the form.
You have filed your affidavit.
The form, you have filed the affidavit, long backlog.
Now, what do you say about the violation?
Violation will follow the 2006, we're strictly following the 2006 rule, my lord. We'll file the affidavit on 21,
No, no,
24,
no.
1 to 5.
What do you say about the violation?
No,
There is an order being passed not to commission.
my lord,
You have
that I have to
permission.
speak, I have to apologize, my lord. That
No, your apology will
Why
do,
will-
or the apology of somebody
apology.
who have done it will do.
my lord,
The person who inaugurated,
maybe, my lord, but they are not in office now. That was 19, my lord.
who inaugurated?
That information I don't have it, my lord.
Then,
The inauguration is taken, that instruction I have it. my lord.
should this court close the eyes then when the interim
That-
order
it
passed
was
by this
it
court
was
has been
it
big?
Direct, will close
Eh?
that station, my lord. We'll
Huh?
close this station, my lord.
Then what to do?
We'll have, I'll, if required, my lord, I'll have a file an affidavit for apology, my lord.
I think better you do it.
By the current, present commissioner, my lord. He has
I
done
think you
it,
better do it. Then only I think we should proceed.
Lordship.
And you just find out what to be done. I think some logical something needs to be done because you see, these garbage stations are also required. You can't have very long, a person can, you can't ask this garbage station to have only one at that far off place. There's some place, but there's, and if it is near the vicinity, because here the garbage is collected from where?
From every
households, by a small
Understand.
household, it comes there.
and a small.
Mr.
vans-
Bora, this court also, I also stay in Guwahati,
Yes,
so I
sir.
know that. But I am saying in which area? The area of this garbage station, which one?
Well, there, this serves two division number 4 and 5. There are 6 division, my lord.
Area?
Yeah, my lord, this is VIP road to this Narangi and all this
6
part,
mile.
6 mile, that's all this part. Including that Ganeshguri area. also.
So that is the area for which the garbage is
Garbage
done.
are
Prior to that, what were you doing?
Straight away to the landfill side at Bolagaon. That's why the LDT has stopped us.
And why is it necessary now to have it there?
Well, because there here segregation was not possible. Once it reached the main landfill site, segregation is not possible. Here you have to segregate it and that is segregate the garbage, then you send it to landfill site. Then the machines are there.
You
to
do one
segregate
thing, you file an affidavit. How much is the area?
Yes.
And also show me on the next date, which is the violation they have occurred out here. And if there is any violation, we'll take care of it. And in the meantime, you file an affidavit
Lordship,
for apology.
Lordship.
Else we have to initiate contempt under 215. The petitioners have filed an additional affidavit
We have already brought on record, my lord.
wherein the order passed by this court dated 5/1/2018 has been enclosed, as well as certain pictures which would show that the garbage station, which was directed not to be commissioned without the leave of the court, is seen to be in operation. Taking into account the above, this court directs the Commissioner GMC to file an affidavit in respect to the contents of the additional affidavit. List the matter again on 28th of August 2023.
My lord, pardon me, my lord. What should we file, my lord?
You don't file anything, you just find out that what is to be done, because you see, the garbage station has to remain.
Yes.
But
I understand.
can these courts do something so that
There is a
give you something
Yes.
so that they have to compensate you for the lack of use or something?
Yes.
Something just kind of.
My lord.
Okay.
Obliged.
Yes, Mr. Sharma, your matter, it will be a 46. Let us take, he once says that it won't reach.
Not reached that to the my, but matter should be the admission, my lord. If, other side, look at APR against the High Court and look at the APR.
Mr. K. Sharma appeared by the order dated the registry was directed to list the matter showing the name of the standing counsel in the cause list. In the instant case, the district judge Bimahasa or the civil judge so are respondent. Counsel is directed to show the name of the standing counsel of the Guwahati High Court in the cause list. Has it been shown? Names of Guwahati High Court councils?
Yes,
Sure.
appeared on the first day, now it is shown in the call list also today.
What is your case?
Actually, regarding the appointment or promotion of the head Jarikar, my lord. The Jarikar has to be promoted from the head Jarikar or Jarikar. But here outside the court gate, the peon was appointed as head Jarikar. This is the challenge.
Issue a
Moreover,
direction in the
here-
nature
here
of
you have
tertiary
circular of the High Court.
quashing and cancelling the advertisement issued by the so far as relates to one promotional post of head Jarikar at and also cancelling the setting the selection of and selecting and appointing the respondent number 5 in the promotional post of head Jarikar. Mention the petitioner in the What about the service upon the respondent number 5?
private respondent,
Huh?
private respondent.
Understood. What about him? Whether the service has been meted out?
He did not appear notice, here is the notice.
How do you know?
Yes, I was informed. That here is some notice.
Huh?
In the employee of the establishment, he is promoted.
To join
You are not
no,
Jarikar,
there's
he is
nothing on the office note. Office note code hai? No. The office note code. These are cover. Eh? Very good. Itu to mutak dishe, itu to dia sabi dia, बहुत दिन आगे. So done long time. Office note na hai. Huh? Okay. You take steps upon respond number 5. Press steps.
Yes, we will take it, but here if it will know it.
It is not seen from the records. It reveals that the record from the records that the service upon the respondent number 5. It is not seen from the records as to whether the service upon the respondent number 5 is complete. Oh. Oh. Well, I know why. Notice was not issued to the respondent number 5.
He has not received.
There's no notice issued till now. Only notice has been issued to 1, 2, 3, and 4.
So 1 to 3, they have appeared on the first.
Understood, but if you are asking for quashing of a respondent number 5's appointment and no notice has been issued.
Sent it, but we have already sent it. We have received it.
How could you send it when the court has not issued notice?
Would take time.
Okay. Lekho. It is seen from the records that on 24/2/2021, this court issued notice only upon the respondent number 1, 2, 3, and 4. However, no, it is further relevant to take note of that in the instant writ petition, there is a challenge to the appointment of the respondent number 5. And there has been no notice issued. Accordingly, this court issues notice upon the respondent number 5, making it returnable on making it returnable on 18th of September 2023. The petitioner shall take steps by way of registered as well as usual by Monday, that is on 14th of August 2023.
Okay.
You want to do it by Dusty also?
Yeah. Yes.
The petitioner is further given the liberty to serve.
Will send by registered post
Okay.
because he is the employee of the district judge establishment. He will definitely receive it.
Yeah, he is working in the district judge's office.
Your lordship will pass the order if possible to justice.
The petitioner is further given the liberty to serve the respondent number 5 by way of a dusty routed through the registry of this court and file an affidavit of service on or before the next day. 11. Yes, you're going to pay?
My lord, I have taken up the matter with my client. My lord, their contention is this in regard to section 171 of the MBA. My lord, the interest is simple interest only. Now, the way we made the calculation, they said it becomes compounding interest. So therefore, Lord, what they have said that the 12 lakhs to which they have agreed, that to that amount there will it will carry no interest. And after deducting that 7 lakhs and all, to that they're agreeable to. And on that contention only, the matter was
But
settled.
Mr. Dutta, that is not clear from Justice Bhuiya's order. Justice Bhuiya's order is, I will explain it to the BE, to say that the interest so to be payable shall be after taking into account the 12 lakhs which have been paid. That's all. Because you see, at that point of time, the amount was something like 29 lakhs or something.
19 lakhs.
19 lakhs. You have paid 12 lakhs. Very well, fine. As regards the 17 lakhs, you have to pay interest on that.
Lord, if I read the order, which is at page 5, the last 2 paragraphs.
Yes.
On proper instruction, he submits that in the spirit of the Lok Adalat, insurance company is willing to withdraw the appeal. However, it submits that the amount already paid by the insurance company should be deducted while computing the interest amount.
Yes.
In view of the fair submission made, this appeal is disposed of on withdrawal on the following terms. The balance amount shall be deposited by the insurance company in the registry of this court within 30 days from today, whereafter claimant will be entitled to collect the said amount on proper identification. Now, these two lines, it is made clear, the amount already paid to the claimant would not be taken into consideration while computing the interest amount. That means on 12 lakhs, my lord, no interest will accrue.
Obviously, because the amount has already been paid to him, so you can't impute interest on that. But the interest which has accrued on 19 lakhs, the amount which was directed on 19 lakhs of plus 9%, that amount which have been there, that amount of that 19 lakhs plus 9% as on the date from the date of the institution would be coming to how much? 25 or 27 lakhs or 30 lakhs. So the minus will be 12 lakhs and remaining on that, you must have paid some 11 lakhs or 8 lakhs or whatever may be. And then till that amount is paid, the interest has to be paid.
No, my lord, in if we assess that way, my lord, the interest amount has already included. And the interest will be.
Are you
again-
saying that isn't that the award was not on, the award said 19 lakhs 27,548
Yes,
plus 9% interest from the date of institution.
my lord.
So how much does it come to? I gave you. Give me the chart. Are you giving me the one which I have done it? No, I will not make the calculation. Give it to me. $19 lakhs plus 9%. The total amount comes to 29 lakhs 32,777 as on the date on which you were supposed to, on the date on which you paid this 12 lakhs. The total amount was 29 lakhs 32,777 as on the date on which you paid this 12 lakhs.
My lord, subject to what your lordship said. My lord, what I could gather from their understanding that this particular case was settled on the understanding that on 12 lakhs, there will be no interest. On the balance amount, interest will accrue from the date of filing till realization.
Are you saying that out of the 19 lakhs, 12 lakhs, there won't be interest from the date of institution?
Well, because they have said.
That is not clear from the award. That is not clear. That there won't be any interest on that 19 lakhs, 12 lakhs. The amount this order only says the balance amount shall be deposited by so and so. The balance amount will be which one? The balance amount after which has accrued after the payment of this 12 lakhs.
It's a matter of all interpretation. Because I could understand from their saying that on the understanding that we shall, whatever amount that is 12 lakhs they have paid, on that amount there will be no interest. After deducting from 19 lakhs to 12, 7 lakhs and odd it is coming, interest will be accrue on that amount from the date of filing till realization. And therefore, my lord, on that understanding, it was settled.
We are not setting aside this order. This order remains. We are only going on the question of non-payment. So you do one thing. I will clarify this. You file execution proceedings before the tribunal. Again. The hook. The instant repetition. You are only asking fully comply with that. You are not setting aside that, na?
Lordship, to pay
You,
the,
you are not asking for setting aside that order,
Lordship, I am praying for only for that time.
complying.
Yes, my.
The instant writ petition has been filed, seeking a direction that an order dated 12/11/2016 passed in MAC appeal number 50/2015 by this court be complied with, and also seeking a direction upon the respondents that is the United India Insurance Company Limited and its officials to pay the balance amount to the petitioners, It reveals from the records that an award was passed on 28/2013 in MAC case number 230/2009 by the member Motor Accidents Claims Tribunal, Punitpur Tejpur, whereby an amount of rupees 19,27,548 was arrived at as the just and reasonable compensation, and it was further awarded that the said amount of rupees 19,27,548 would carry an interest at the rate of 9% per annum from the date of institution of the case, that is on 7/7/2009 till realization. Further to that, an amount of rupees 1,000 was also imposed as cost. It appears that the respondent numbers 1, 2, and 3, the respondent number 1 filed an appeal before this court, being MAC case number 50/2015. That is almost after 2 years from the passing of the said award. The said appeal was admitted, and there was a direction to deposit 50% of the said awarded compensation. In terms with the said directions, the respondents herein, who were the appellants in MAC appeal number 50/2015, deposited an amount of rupees 12 lakhs. The matter was taken up was placed before the Lok Adalat held on 12/11/2016. In the said Lok Adalat, the following order was passed, which is reproduced herein under page 33 and 34 of the same order. Pursuant to the said award order, An amount of rupees 11,50,000 was paid to the claimant, oblique the petitioner, in the month of March 2017, which, as per the respondents, is the full and final settlement pursuant to the order dated 12/11/2016. It was the case of the petitioners herein that the petitioners were entitled to a further amount of rupees 8,12,100, which was not paid in terms with the order dated 12/11/2016. And as such had represented before the respondent number 1, respondent number 2, by communications dated 5/6/2017, 15/6/2017. Taking into account that nothing has been done on behalf of the respondents, the instant writ petition was filed. It appears from the records that this court had issued notice making it returnable by 4 weeks by an order dated 20/11/2017. In pursuance to the said notice, an affidavit was in opposition was filed by the respondent numbers 1 and 2. In the said affidavit, it was mentioned that one Mr. A. N. Das, the officer who represented the insurance company, had submitted that the appeal may be settled provided the amount already paid to the claimant of rupees 12 lakhs would not be taken into consideration while computing the interest amount. In paragraph number 5, it was mentioned that the total awarded amount was rupees 19,27,548. And after deducting 12 lakhs, the amount is rupees 7,27,548. And the total interest thereupon, and the total interest on rupees 7,27,548 till 12/11/2016 was rupees 4,81,856. And as such, after deducting an amount of rupees 50,000, and accordingly, after deducting the required TDS, the amount was duly paid to the petitioner, which is rupees 11,13,033. This aspect of this calculation can be seen from Annexure Roman 2 to the said affidavit in opposition. Yes, Mr. Talukdar. Counsel for AG. What is this type of calculation you have done?
Lordship, from that is 7/7/2009, that is the total amount 19,27,500.
So the total interest come to 10 lakhs 4,000.
Yes, my lord.
So total amount will be 29 lakhs 31,000, 32,000 or something. Then 12 lakhs goes minus from there. Okay. Then the amount remains how much? What type of calculation you have done? Even after showing you how this is to be done,
Lordship, total amount was 19,27,540, and their made amount 12 lakhs is paid. Lord.
the respondent counsel have understood my argument, what I have stated. The petitioner counsel is not understanding, in spite of the fact that I have given it in clear handwritten thing, how is to be done. And you represent the AG. Sorry, state of affairs. You should have asked your client to do it.
Is made by my CA, Lord.
This one.
Yes, Lord.
You have charged interest on what amount?
Remaining from the Lordship.
7 lakhs.
Lordship, after deduction of 12 lakhs, my lord. From the amount of 19 lakhs. Lord.
Why are you doing from 19 lakhs? Have I not told you that this 10 lakhs has to be added out there to this 19 lakhs till that period? Then also have you not understood it? In spite of me writing it out here to you, which no court does it. Where is Mr. D. Mondal? Get him. He will calculate it to you easily. You should get hold of an MSc lawyer. They will know it immediately. Or start practicing MSc. Yes, Mr. Dotto, kindly help this court. That is a different thing. You may switch off your mic. But the thing is, how the calculation, I know this calculation is done in this manner. I'll dictate it how it is, but ask them to calculate and give an amount.
Computation made by your lordships. That's the thing, my lord, your lordship has shown.
It has to be done in that manner. And in spite of doing it, he doesn't understand it.
He is going by the idea of CA, my lord, they have their own sort of calculation.
I've heard the learned counsels for the parties and peruse the materials from the court. Taking into account the contesting stand so taken by the petitioner as well as the respondents, this court deems it proper to understand, deems it proper to take note of the order dated 12/11/2016, which have already been reproduced here in above. This order, in the opinion of this court, has to be read with the award, judgment and award dated 28/2013, passed in MSc case number 230/2009. As already stated here in above, the learned tribunal have awarded an amount of rupees 19,27,548 along with interest at the rate of 9% per annum from the date of institution of the case, that is on 7/7/2009 till realization. In addition to that, an amount of 1,000 rupees have been awarded as cost. This court, by an order dated, when was that order passed, by which interim order was granted? When did they deposit that amount?
Lordship, they deposited the amount on 21/12/2016, Lordship. We
Huh?
registered. In the affidavit, Lordship, it is there.
Good, sir. It appears from the records that on 27/2/2015, this court directed the respondent herein, who were the appellants in MAC appeal number 50/2015, and directed in Miss case number 490/2015, arising out of MAC appeal number 50/2015, to deposit 50% of the said amount. And on the basis thereof, the amount was deposited on, when did you deposit, Mr. Doctor?
So 12 lakhs, my lord.
When? Oh, yes, 12 lakhs.
That was, my lord,
Not from the date he has taken.
23/4/2000.
Hmm?
23/4/2015, Lordship. Annexure 2 of the affidavit.
Lecture 2.
yes, 23/4/2015.
Huh?
At page 6 of my affidavit, annexure 2,
Okay. That
second para,
deposited
your lordship will find.
the amount of rupees. On 23/4/2015. First. This court finds it relevant at this stage to take note of the total amount payable to the petitioner as on 23/4/2015. As per the award dated 28/2013. The total amount was the said amount comes to 19,27,548 plus 9% interest with effect from 7/7/2009 to 23/4/2015. That is 5 years, 9 months, 20 days, which comes to rupees this. Therefore, the total amount as on 23/4/2015 was 19 lakhs. Itu koibo plus a amount of for 5 years, 9 months, 20 days. Therefore, the total amount as an amount of rupees 12 lakhs was duly paid, deposited, The remaining balance amount comes to this. Any calculation at a Korea 10 lakh 5,200 plus 19 lakhs 29 lakhs 32,000. Yar logot ako 1,000 doka logabo lagibo ti cost ase. Plus 12 lakhs. Minus 12 lakhs hole total iman. Okay. Now let this court take note of how the calculation is to be calculated as to when an interim or when there is a deposit so made in terms with an interim order. The Constitution Bench in the case of Gurpreet Singh versus Union of India reported in 2006 8 SCC 457 have duly taken this have duly opined in the said opinion. As to how the said amount, how the amounts so paid pursuant to interim orders are required to be adjusted. This aspect of the matter can be seen from paragraph number 52, which is reproduced here in under. From the above, it would be seen that the Constitution Bench had opined that when part of an amount awarded by the reference court or by the appellate court is deposited pursuant to an interim order of the appellate court or the further appellate court, and the awardee is given the liberty to withdraw that amount, in such a case, the amount will be received by the decree holder oblique the awardee on the strength of the interim order, and the apportion will be subject to the decision in the appeal or further appeal and the direction, if any, contained therein. It was further observed that in such a case, if the appeal is disposed of in favor of the decree holder, oblique the awardee, the decree he would be entitled to appropriate the amount already received by him pursuant to the interim order, first towards interest, then towards cost, and then the balance towards the principal as on the date of withdrawal of the amount, and claim interest on the balance amount of the enhanced compensation by levying execution. It was further observed that on the part of the appropriated, on the part appropriated towards the principal, interest will cease from the date on which the amount is received by the awardee. It was further observed that if, while passing the interim order, the court had indicated as to how the deposited amount is to be appropriated, that direction will prevail and the appropriation could only be done on the basis of that direction. In the instant case, while disposing of the miscase number, 490/2015, thereby directing the directing the respondents herein to deposit 50% of the amount. By the order dated 27/2/2015, there was no any direction as to how the amount is to be apportioned. In the backdrop of the above, let this court therefore take into consideration the direction so passed in the order dated 12/11/2016. It would be relevant to take note of it. In the said order, this court had duly taken into consideration that the respondent herein, the respondent insurance company herein, that is the appellants in MAC appeal number 50/2015, had submitted that they are willing to withdraw the appeal. However, stated that the amount already paid by the insurance company should be deducted while computing the interest amount. And this court, therefore, by the order dated 12/11/2016, permitted the withdrawal with a direction to the insurance company to deposit the amount of rupees, the amount within 30 days from the date of the said order. And further clarified that the amount already paid to the claimant would not be taken into consideration while computing the interest amount. Meaning thereby, this court, by the order dated 12/11/2016, while disposing of the appeal, directed how the amount which have been already deposited in pursuance to the interim order is required to be apportioned. Therefore, the scope and therefore, it is the further opinion of this court that as on the date on which the amount of rupees 12 lakhs was paid, therefore, it is the opinion of this court that the amount which have been paid as rupees 12 lakhs could not have been apportioned It is further relevant to take note of that after the payment of rupees 12 lakhs on 23/4/2015, the balance so payable was rupees 17,32,777, and the said amounts and to the said amount, and interest shall accrue at the rate of 9%. At the time of withdrawal of the said appeal on 12/11/2016, the total amount which was payable to the petitioner was rupees 19,27,548 plus 9% with effect from 7/7/2009 to 12/11/2016. And in normal circumstances, applying the law as laid down in Gurpreet Singh, the amount of rupees 12 lakhs were to be apportioned first towards the interest, then towards the cost, and then towards the principal. However, in view of the directions which have been passed on 12/11/2016, the interest shall only accrue at the rate of 9% on the amount payable to the petitioner after deducting the 12 lakhs as on 23/4/2015. Therefore, the petitioner would be entitled to an amount of rupees 17,32,777 plus 9% with effect from 23/4/2014 till the realization. It is further seen that an amount of rupees 11,13,033 was paid on when?
21.
This is the best thing when you don't get the help of the petitioner counsel.
21/12/2016, my lord.
When?
21/12/2016.
21/12/2016.
16.
Therefore, the amount which the petitioner now would be getting would be a amount to 17 lakhs. You do the calculation, Mr. Taluga, 17,32,777 plus 9% from 23/4/2015. Write it down. What is the date? You got the money? 23?
23/4/2000.
21/12/2016.
2016, madam.
21/12/2016. You make that. How much it would be at the rate of 9% from 23/4/2015 on this 17 lakhs. And then thereafter, minus that with this amount of rupees 11,13,333. Whatever amount comes thereafter, then it will again have an interest at the rate of 9% till the date of realization. In that view of the matter, the instant writ petition stands allowed, thereby directing the respondent numbers 1, 2, and 3 to deposit the said amount above arrived at within 30 days before the registry of this court. It would have been better you compromise and matter could have been ended. This now amounts will go very high.
In the bills to them, madam, that tax deduction is sold, that is at 10% we are supposed to deduct it, that we are not done. And this continued from 2011 to 2017. There was no intimation from the income tax authorities that it will have to be deducted. Now in 2018, during the period 17 and 18, suddenly they wrote a letter to us at page 26. What you will find at page 26. That on spot verification, they have found that, my lord, we are not deducting that TDS.
and it has not been deposited to their account. Lordship will see it is dated 9/2/2018.
Then,
My lord, thereafter, my lord, there was some correspondence between the authorities. And finally, my lord, in page 28, we informed that page 28, by later dated, my lord, 13th of February 2018. They informed, my lord, the NHM that otherwise, my lord, they are not required to pay the income tax because they respondent fees, my lord, exempted from that. Lordship will see, my lord, the heading, my lord, clarification of non-deduction.
then what happened?
Thereafter, my lord, at page 29, the income tax authorities, they,
Should the show cause?
no, my lord, at page 29, on 14/2/2018, they submitted this particular format to give details of requisition of details of TTS in respect of Emergency Management and Research Institute, EMRI, that is the response number 3. Accordingly, my lord, we have forwarded it to the state authority. And in the meantime, on page 31, there is a so-called as to why penalty and interest should not be imposed as per section 201(1) for violation of, my lord, of section 194A. There is, my lord, non-deduction of TTS. Here, my lord, at page 32, we submitted our response to the authority, clarifying everything, my lord.
Lordship, may I submit, Lordship? The main issue, Lordship, that is regarding, my lord, the additions of, based on, my lord, no TDS was deducted. And in the meantime, they have filed a rectification petition, my lord, and that petition has been allowed by the authorities. So, my lord, after allowing that, after rectification petition has been allowed, my lord, now the amount become, my lord, from 11 crore to 4 crore, my lord. And, my lord, in the impugn order, my lord, because they are, the entire challenge is, my lord, the amount of 6 crore something, my lord, that your lordship will find at page 43 of the petition, lordship.
11 crores, 80 lakhs.
Lordship, that is, my lord, the demand as per traces, lordship, that is the TDS amount, 6 crore 84 lakhs. That has been allowed, and, my lord, this has been reduced, my lord. My lord, the authority has subsequently passed an order, my lord, that is, my lord, not on record, my lord. In view of the subsequent order, my lord, the petition become infructuous, my lord.
But that part, my lord, you will have to bring it on record, my lord.
But I'll file an.
No.
No, my lord, there is
No, Mr. Gogoi, you have filed the rectification.
for non.
No, who filed the rectification?
Lordship will,
No, who filed the rectification?
no, we have filed it for non-rectifying that part, my lord, we have moved this honorable court. And on
Understood.
top of that, there is still a issue, my lord. There's after, my lord, supposingly they have admitted that, my lord, 6 crore that they have inadvertently given it in the demand notice. But what about that 4 crore?
Why have you moved the rectification after filing the petition?
No, before that, it's part of the petition, my lord, page 45. Without leave of the court, they have done it, my lord. It's in our favor, we have nothing to say. But the issue still remains, my lord, about the 4 crore.
No, what is
Whether
your,
the
let us
respondent
see
number-
your rectification, that petition at page 45, read it.
Yes, with a reference to the subject cited above, I am to inform you that we are in receipt of the aforesaid order dated 27 March 2018, wherein a demand of rupees 11 crores 80,000, 80 lakhs 8,720 has been determined. It is to be mentioned that on perusal of the order, we have found that a sum of rupees 6 crores 84 lakhs 60,590 has been added to the total demand, being demand as per traces. We have checked the website of traces and have found that no such demand exists for the aforesaid assessment year. This is a mistake apparent from record. The mistake being apparent from record, we'd like to request to rectify the same and reduce the demand by rupees 6 crores 84 60,590. Please note that we intend to appeal against the aforesaid order, and as such, request to pass necessary order at the earliest noted. Appeal can be filed within time allowed as per IT Act, and 20% of the disputed demand can be paid for granting of day of demand.
Then,
Then, my
once you have submitted this,
lord,
then the thing is, you want to file an appeal
No,
after the
no,
rectification has been done.
But the issue still remains, my lord, regarding, my lord, whether we are liable to pay the rest of the, my lord, 4 crore. Respondent number 3. My lord, there is a certificate, lordship may kindly see there now.
You say that you are going to file an appeal. Why should this court at all interfere when there is an appellate forum? If you are there on the other side, you would have jumped out and said that there is an alternative remedy, which you normally do. And then, why should this court at all interfere? You want to, there is a rectification order there to that effect, you file an appeal against that. Why should this court at all interfere? I understand your point out here is, look here, when the amount is not liable to be paid, it is income tax exempted, why should this court at all, why any amount has to be paid or not? But you see your document out here where you clearly mentioned that you are going to file an appeal.
Difficulties, my lord, again, my lord, for even if my
You have the rectification order?
Lordship.
Give it to me. Athens, you go and appeal.
my lord, again, my lord, will have to pay about 1 crore for
So,
admission of
is
that.
mission, what is that? Mission Director, National Health Mission is less? Go and talk it out with these people out there. You have a particular thing, no?
My lord.
One should not keep on fighting amongst your officials.
Lordship, in this regard, my lord, today he has just now informed, at least, my lord, lordship may take up on Wednesday, my lord.
For what?
Whether they would like to prefer the appeal or.
On last occasion, you said,
No.
no, Mr. Bogowai,
Yes,
kindly answer. No, on the last occasion, you say
My lord.
that, my lord, I have to take instruction. Let it be taken up on Friday as to whether the issue survives.
It still survives, my lord, because the impugn order, the assessment order is still there, my lord. That's why
For
I'm saying
what? You
No.
wanted to file an appeal, go and file an appeal against this order.
It's under challenge, my lord, in the petition.
No, why
Yes,
should
yes,
this
Lordship
court at
makes
all
it-
want, when you wanted out here categorically stated you were going and filing an appeal?
First prayer is there, my lord, praying for such agreement.
Huh?
Yeah, lordship may see the prayer.
Why should this court interfere and do all these things out here in this case?
My lord, here, my lord, pleadings are complete, my lord. The respondents have filed their affidavit.
So what? Respondents have filed their affidavit. Does it mean that this court, when you have your own stand is that you want to file an appeal? And then you have approached this court.
My lord, in fact, after passing of the rectification order, my lord, fresh cause of action arises.
Absolutely. How can this court keep on listening to all this thing? You are from 2018, the matter is
Then, my
pending.
lord, lordship may give that observation, my lord. Will be at liberty either to prefer an appeal or, my lord.
You know it,
Order.
whether this order has been communicated to them?
Yes, lordship. In fact, their acknowledgement is there, my lord.
Oh, very much. Office of the Assistant Commissioner, TDS. Acknowledgement is where?
The last page, lord. Acknowledgement slip, my lord.
Yeah.
And down below, my lord, there is a
You have
signature
received
and
it on
seal.
25/10/2019.
Lordship.
You have not challenged it. Why should this court do anything out there?
My lord, issue is pending, my lord, that's why. The issue is otherwise pending here, my lord. In fact, my lord, there is an interim order which says that, my lord, they will not act upon this particular order of assessment. Now, how could they, my lord?
No
submit-
order. Is there an
Without
interim order not to pass any order on the rectification?
No, lordship. Lordship, in the interim order, lordship, last paragraph.
Considering that the order dated so and so issued by so and so
Lordship.
That is a demand notice, my
under
lord.
Iman and against the petitioner and during the pendency of the application dated so and so.
If 27/3/2000
Iman made by the
remains suspended,
petitioner before the
how
income
can they
regarding
rectify it,
the
my lord, make it 4 crore? That's why I'm
see
saying
the
that I have
interim,
no problem,
no,
my lord.
Mr. Gogoi, see the interim order. Considering the above impugn order dated 27/3/2018 issued by the Assistant Commissioner of Income Tax TDS under section so and so against the petitioner and during the pendency of the application dated 11/4/2018 made by the petitioner before the income taxer regarding rectification, the operation of the impugn order shall remain suspended. The order is no longer there.
No, it was suspended there.
No, it was suspended till the decision on your 11/4.
My lord, so far as the otherwise the delay part, if at all, tomorrow if you prefer, that
This
observation.
court,
may be
Kanda,
placed.
you say whatever you must say out there in whatever area. Where is that? On this metro? Okay. The instant writ petition has been filed
Only thing, my lord, that of
challenging the order dated 27/3/2018 passed by the Assistant Commissioner of Income Tax TDS Guwahati for the financial year 2010-11, whereby an amount of rupees 11,80,008,720 was assessed to be the TDS liability to be payable by the petitioner. Full stop. It further appears from the records that pursuant to the said order dated 27/8/2018, the petitioner submitted a request for rectification of mistake under section 154 of the Income Tax Act 1961 before the Assistant Commissioner of Income Tax, TDS Circle, Guwahati. Relevant herein to mention that in the said communication dated 11/4/2018, it was mentioned that there was a mistake apparent from the records as regards a sum of rupees 6,84,60,590, which was being added to the total demand, being demand as per traces. And from the website of traces, there is no such demand exists for the said assessment year. It was further mentioned that the said rectification be carried out by reducing the demand of rupees 6,84,60,590. At the earliest, so that the petitioner is in a position to file the appeal within the time allowed under the Income Tax Act, and 20% of the disputed demand can be paid for granting of the stay of demand. It reveals from the records that this court, by an order dated 18/5/2018, issued notice. Notice was issued or not after such a long order?
18/5/2018.
Where's the issue notice? And further observe that taking into account the impugned order dated 27/8/2018 issued by the Assistant Commissioner of Income Tax TDS Guwahati against the petitioner, and during the pendency of the application dated 11/4/2018 made by the petitioner before the Income Tax Authority Department regarding rectification of the mistake, the operation of the impugned order dated 27/8/2018 shall remain suspended till the returnable date dated on 19/6/2018. It further appears that the interim order was continued from time to time, and by an order dated 25/1/2019, This court directed the matter to be listed again on 14/2/2019, and the interim order was directed to continue till then. Thereafter, the record shows that the interim order had not been continued. Be that as it may, Mr. S. Chetia, the learned counsel appearing on behalf of the Income Tax Department, had submitted that on 25/10/2019, the Deputy Commissioner of Income Tax Circle, TDS Guwahati, had rectified the earlier order dated 27/8/2018 in exercise of the powers under Section 154 of the Income Tax Act 1961. And thereby, the demand of rupees 6,84,60,590 was reduced, and the total payable amount was assessed at rupees 4,95,48,128. It is further relevant to take note of that on the same date, notice was issued to the petitioner, that is on 25/10/2019, and the same was duly received on the same date, as could be seen from the acknowledgement issued by the finance manager of the State Health Society, Assam. The rectification order, as well as the acknowledgement and notice, as well as the acknowledgement, are collectively enclosed, collectively kept on record and marked with the letter X. Taking into account the above, and more particularly, the communication dated 11/4/2019, wherein the Mission Director, National Health Mission, had categorically mentioned that an appeal would be filed after the rectification is done. This court finds no reason to decide to adjudicate the instant writ petition any further. In view of the fact that as there is an adequate and efficacious remedy provided in appeal proceedings, provided under section 261.
Lordship.
Eh?
Lordship.
261 or what?
I'll check Lordship. I'll find it.
261, I think. Appellate authority is 261. 263 is reference, huh?
Lordship. I'll just find it.
Sixty-one is an appeal to Supreme Court.
Lordship 251, Lordship.
251.
Lordship.
Under 251,
250 subsection 1.
250 subsection 1 of the Income Tax Act 1963 or 61. So that there must be some provision out there for condonation of delay, na?
Lordship. Yes. Lordship.
There, 100% there will be there,
Lordship.
provided that the appeal may condone the delay. So, give it to me. Let me touch also the Income Tax Act.
Lordship, one year from the end of the financial year in which appeal is made.
No. Let us see. Now, this is the powers of the commissioner, no? Procedure. No, 251 is shall fix a date. No. Appeal lies to whom? Appeal is appealed by a person denying to deduct tax in certain cases. This will be done under 248. What a thing. Appealable orders before commissioner. Subject to the provisions of the SSC and Iman may be by the following order of the assessing other than the Iman. May appeal to the deputy commissioner appeals before 1st of June against any order. This order was passed under what provision?
My lordship,
201.
201.
201.
Rectification was done under section 154.
It's okay, but where under an agreement or other arrangement, the tax deductible on any income other than interest under so and so is to be borne by the person to whom the income tax is payable and such has paid the tax to the credit of the. Now, the power under is 201. Yeah. This is under 246A. Under 246A. Appeal life. An appeal lies under 246A of the Income Tax Act. Huh? Huh. 46. This court also finds it relevant, finds substance in the submission of Mr. B. Gogoi, the learned counsel appearing on behalf of the petitioner, who submits that in view of the pendency of the writ petition, the appeal was not filed. This court, taking into account the provisions of section 249(3) of the Income Tax Act 1961, whereby the commissioner appeals have been conferred with the discretion to condone the delay for sufficient cause for not presenting the appeal. Observes that if an appeal is preferred by the petitioner within how much?
30 days.
Within 30 days from the date of the instant order, the commissioner appeals shall duly take into consideration that in view of the pendency of the instant petition, the petitioner had sufficient cause for not presenting the appeal within the period. With the above, the petition stands dismissed.
Deeply oppressed.
Yes.
Party.
Yes.
My lord.
Madam, what is it?
Yes, my lord. My lord, respondent number 3, file is additional affidavit in opposition, my lord, today only.
What is this? What do you want?
So 2 weeks time to take instruction, my lord.
What are you asking? Some representation of 9(8)?
My
My
lord.
lord,
What is that?
it is addressed to the deputy commissioner. My lord,
For stopping construction of the auditorium of Hudson Mary College mini stadium on the land of the petitioner using force without following due process. It is their land? Huh?
I don't have instructions written to them, my lord.
The issue involved in the instant writ petition. No, the petitioner has approached this court being aggrieved by the actions of the respondent authorities in carrying out construction over the land of the petitioner. This court made a specific query upon the learned counsel appearing on behalf of the deputy commissioner, South Salma, Mankasar district, as regards any instructions, to which she submits that she has no instructions. List the matter again on 30th of August 2023, on which day Ms. S. Sharma shall obtain the necessary instructions as regards the representations so submitted by the petitioner.
Failing which, my lord, consequential action be followed. If they may be aligned, failing which consequential action.
What?
Failing which, my lord,
You get this,
I
then
don't budge.
14. First day it won't be proper.
It's been many days, my
Then these people may think that on the first day this court issues, so this is.
lord. Many days have passed.
No, we'll see on that day, and then you know what is there. Yes, Mr. Fukan, what is your matter?
My lord, this government land is public utility land, my lord. It is occupying by the public respondent number 3, my lord. That's why this.
Illegally
can expire.
occupying the government land. Silkhaku village. Oh, who is in Silkhaku village?
Sila Saku, my lord, it is at Morigaon district, my lord.
Somebody is there. You want them to be evicted, and the government is not doing anything.
My lord, it is everybody, all the matter is admitted by the government, my lord, that it is.
No, why are you before this court?
Because I am the villagers, my lord. It is a public utility land, my lord. It is playground used by the villagers and to graze their cattle, my lord. And this land is
Are you saying that this is a community land?
community. I cannot say, my lord. It is a.
You are there?
public utility,
So I'm
my
in
lord.
person.
Who are you?
Respondent number 3, sir.
3.
Yes.
Why are you in person?
Sir, I have applied for in person.
Huh?
I have requested the higher.
Yes, tell me, what is this? Why are you in possession of some government land?
Your Honor, with due respect, sir, this land was in my possession, like all Torju land, for almost 7 years. And I got this land to set up the school. There is a Miadi land besides this land. So the landowner from whom I purchased, like the dark number is 259 written here. So the dark number 260 I purchased in paper. But the poor farmer, he never knows which is 260, 259. So actually he sold me 259 in person. But later when I come to know that this is a government land, but this is called Torju. Torju means for which we pay Bedokali Khajana. So this fellow was paying Bedokali Khajana since 1965. We have given the all Bedokali Khajana receipts. And then we have that I got in the possession against cash and kind. Like I paid him some money and his son was employed in the school, Ranjit Deka. So it is going, everything is fine, sir. But a nearby club, which is Khilchadu Gyanjyoti Puthi Bhadal, they have put some baseless allegations. I have put in affidavit. This land is never been a part of playground, sir. You can see the geographical location, you can see the trace map, everything, sir. So this land was given to me, and when I applied, so they asked me to put as a landless person, because as per land policy 2019, if you are having crop field below 7 bighas, then you are counted to be landless. So in the meanwhile, I have again procured around
Sir, 2 bigha 3 kathas for my school, their side. So the petitioner has said, ki when I have already 2 bigha 3 katha land, how can I be landless? So that is has been put in question now, sir. But the main point there.
What is this Sanskriti Vidyapit?
This is a school, sir, higher secondary school.
How are you operating in a land which doesn't belong to you?
So that land belongs to me.
How?
So that land was in my possession, sir. Like a government land, everywhere it is in possession, Torju land, sir.
Mr. Petitioner in person, kindly understand one thing.
Sir,
Does the land belong to you? Merely in possession for 7 years would not make you a owner of the land if it is a government land. Now, what is your basis to be in possession of a
sir,
government
on
land?
2020, it was allotted to me, sir, by government.
This land was allotted to you?
Yes, sir, yes, sir.
There is an allotment here, sir.
I got allotted, sir.
He has got an allotment?
Yes, sir.
By SDLS.
Huh?
By the
During
subdivisional-
dependency, my lord.
It's okay, very good then. Where is it? Where is the allotment?
That is page 9 of his affidavit.
His affidavit. Let's see. Allotment letter.
Yes.
Annexure A.
Page 9.
Page 9, my. For this-
Therefore, a plot of land measuring 2 villa of
That is the translation.
there has been allotted in the name of Amalesh Medhi, son of Prafulla Nath Medhi of village Manipur. Huh? So this land, government land has been allotted.
Yes.
So nothing remains.
Yes. And in page, my lord, 13 of the repetition, the Das court, the honorable court has asked me what is Gorabat, appearing in page 13.
Uh,
For instruction I received from government.
where? Page
Page-
13 is what?
Page 13 is the Sitha.
Uh,
And the remarks column, it is says Gorabat.
Gorabani? Goraband.
Gorabat.
Gorabad.
Gorabat.
Goraban.
Gorabat means Gorabad, means it's not unusable land, not cultivable, it's a wasteland. That has been given to him. allotment.
Anyways, he has been given allotment.
Yes,
Where's the
that-
question of eviction of them?
My
Yes.
lord, thing is that. on-
You, have you, Mr. Fukun, have you challenged the allotment?
Allotment is during the pendency of the,
So what, have you asked them not to allot? Have you asked for that? No.
my lord, he has,
The instant
Obtain this
petition
land,
has
why
been
not?
filed by the petitioner.
my lord,
I'll give you the liberty.
My
You
lord.
want to challenge
My
it,
lord.
but this matter has to finish. The instant petition has been filed,
not only this land, my lord, there are another land also.
challenging.
3 lands are there, my lord, here. This 1 land is allotted to him, other 3 lands are using by him, my. There are 3 lands, my.
About 478 and 479, what
My
did
lord,
you say?
59, 478.
That 259 he has been given to him. What about 478 and 479?
Report is that they are not using that land.
They are not in, you are not in possession of
I
478.
have got question, sir.
Only
Public is
for
using, I am
one
cleaning.
toilet
As
or
per,
something.
as per the affidavit, my lord, the school is using this land, my lord. It is their affidavit, my lord, government affidavit, my lord.
Where?
My lord, government affidavit is there, my lord. It is affidavit of respondent number 2, my lord. Page 3, my lord.
I'm not in position, I'm using.
Para 6, from para 6, my lord. it
Had
is
applied
page-
for allotment of so and so, accordingly the circle officer so and so allotment granted. Okay, then, okay, the land covering so and so. Gorban having a total area is not under the possession of Sanskrit Vidyalaya. Then
No, my lord.
the land is being used by local community and the students of Sanskriti Vidyalaya as playground.
sir.
So
Yes,
that
sir. Yes, sir.
That,
the instant writ petition has been filed seeking a direction upon the respondent number 3. Now seeking a direction upon the respondents
The issue
to
of
debar the
privatization
respondent
of-
number 3 from illegally occupying the land of the government, DAG number 259, Annexure 2, as well as 478 and 479, Annexure 3, situated at Silkhaku Village, Moza, Niz, Tetelia, Revenue Circle, Morigao, in the district of Morigao, Assam. Full stop. It reveals from the records, and more particularly from the affidavit so filed by the Assistant Commissioner Morigao, that the land measuring 2 bighas, 3 kathas, 13 lechas of Sorkari Gorabon, class Solitoli, SHALITOLI, bracket ko, covered by DAG number 259 of Silkhaku Kisam under Niz Tetelia Moza, has been settled with the petitioner,
Not settled, allotted.
has been allotted to the respondent number 3. Full stop. It has been further mentioned that the land measure covered by DAG number 478 and 479 of Kilkhaku Kifam, KIFAM, under Niz Tetelia Moza, class Sorkari, Gorobond, having a total area of 10 bighas, 4 kathas, 17 lechas, is not under the possession of the respondent number 3. The same land is being used by the local community and the students of Sanskriti Vidyalaya as playground.
Yes.
Taking into account the specific stand so made in the affidavit, in the additional affidavit filed by the respondent number 2, this court finds no reasons for passing any issuance of any writ in the instant petition for which the petition
My lord.
stands dismissed.
I have a submission, my lord, as per the Supreme Court, my lord, directions, the school cannot run on a private land, my lord.
Liberty, however,
Private land, my lord.
school can't run on a private land.
No, playground cannot, school cannot have the playground, my lord. Here is the case flow, my lord,
School cannot run on a playground means what?
my lord.
That's a agricultural land.
No, my lord, I am reading this recent judgment, my lord, of 2023, Supreme SC 187, my lord. Here is paras 4, my lord. There cannot be any school without playground.
Without playground.
Even the student who
Next.
study in such schools are
Okay,
entitled to
18.
government environment.
Item 18.
Next.
My lord, it is.
You
it
want to
is-
challenge the allotment?
Yes, my lord.
Okay. The dismissal of the writ petition shall not preclude the petitioner to challenge the allotment made in favor of the respondent number 3.
My lord. Obliged.
Thank you, sir.
Yes, railways. I saw Mr. B. Sharma. What is this matter about?
My lord, the last occasion, my lord, on 15/11/2022, my lord.
Yes, what is the government file an affidavit?
No, my lord.
Huh?
No, my lord. Till two, my lord.
They have not filed.
Oh.
This court has directed whom to file.
Yes, my lord, they handle it.
Respondent number 5.
Yes.
Okay. Who is the respondent number 5?
This deputy commissioner.
Who is appearing for deputy commissioner? Nobody. Okay. This court, while ordered it at 15/11/2022, had directed the deputy commissioner to file an affidavit within 3 weeks. However, the said affidavit has not been filed. So the deputy commissioner is also not represented by any of the councils. Considering the above, this court fixes the matter on 11th of September 2023. It is directed that if no affidavit is filed by by 7th of September 2023. The deputy commissioner shall be personally present in the court.
Lordship, I appear wherever.
None appeared. Give your names, not his.
19.
None appeared. Your name can be put out there, Mr. Sharma, not the deputy commissioner. Yes.
I'll give the name.
Yes.
But in this case, the petitioner has filed this.
Lordship, in this case, I have received specific instruction, Lordship. Lordship, may kindly peruse the
Instruction was placed earlier occasion also.
What is
my lord.
this matter about?
Yes, sir, this petition is filed for claiming some unpaid dues in respect of a contract work, my lord. And the petitioner,
Is he entitled to?
Lordship, whatever he is entitled, he has been paid, Lordship.
Has been paid
Lords. This is
upon verification.
upon verification.
There is no other amount.
No, Lord.
thereafter, my lord, I have filed an additional affidavit that.
No, Mr. Purkasta, if you have anything, you, in view of that stand, you want to file a civil suit, go and file a civil suit.
That's
This
liberty
court
may be
is
given.
not. Huh?
That liberty may be given.
Period for what?
This is my
When
lord,
was the last payment made?
last.
Lordship, it was made in August 2022.
Okay, take it. The instant petition has been filed by the petitioner claiming certain amounts payable to the petitioner on certain works being completed by the petitioner from the irrigation department of the government of Assam. Mr. N. Upadhyay, appearing on behalf of the irrigation department, submits on instructions so received from the executive engineer Dholai Sonai Division Irrigation that the petitioner is not entitled to any other amount. And the petitioner have received full amount of the bill on the incomplete final work amounting to rupees 50,31,217 during August 2022. In that regard, and the instructions so produced is kept on record and marked with the letter X. The petitioner is permitted to take certified copy of the said communication. Mr. B. Purkasta, the learned counsel appearing on behalf of the petitioner, submits that the petitioner is entitled to further amounts. Taking into account that the issue involved herein as to whether the petitioner is entitled to further amounts would entail disputed questions of facts, which this court can't adjudicate under Article 226 of the Constitution, the instant petition, no orders can be passed in the instant proceedings for directing for further verification in that regard. The petitioner, however, accordingly, the writ petition stands dismissed. The petitioner shall, however, be at liberty to approach the appropriate forum wherein disputed questions of facts can be decided.
Obliged.
20.
This petition has become infructuous.
Infructuous?
Yes, the petitioner already got that.
The learned counsel for the petitioner submits that the relief which the petitioner have sought for have already been granted to the petitioner, for which the petitioner would not like to press the instant writ petition. Accordingly, the instant writ petition stands closed as it has become infructuous.
21.
I'm appearing on behalf of P. Sharma standing on AFDC lawsuit. He's suffering from illnessness.
The learned counsel appearing on behalf, it has been brought to the notice of this court that Mr. P. Sharma, the standing counsel of the AFDC, is unwell and as such seeks for an accommodation. List the matter again on 28th of August.
22.
This petitioner waiting for accommodation, but the allotment is given. But they are rights, my lord, they are the fire victims, and everything is explained in the Annexure C, page 21, my lord. So there is a fire victims are temporarily accommodated in Moscow, my lord, and who are accommodated in Moscow, they should be given allotment in Fancy Bazaar, my lord.
To give
So-
accommodation of rooms and stalls to the petitioner in the ground floor of the Fancy Bazaar market complying to the directions of so and so. Yes, then
My lord,
you are 5 victims. You have given it to somebody else. Why not him? What is this stepmotherly treatment to the petitioner? You've given that day, that matter.
But that matter was outside the building, my lord. He was.
You have given even to some persons who is dead. Remember that matter? Where the system, those were the 5 victims. There were 2 old ladies, and you have given it to them. And then he, as the daughter-in-law, comes up and files a petition out here stating here that I want the room there, not there.
That was dismissed by the division bench.
I have dismissed it on the ground that you could not have.
Not.
It's a different thing. But people who are dead, you have given not to a person who is alive.
But these is that either is a vegetable vendor, vegetable seller. And vegetable seller, my lord,
Whether 5 victims of what?
there's a market in the Fancy Bazaar, 89 it got gutted.
Hmm.
And they were all shifted to Moscow. And Moscow, all the vegetable vendors are now shifted to Pamohi.
You want to go to Pamui?
no, my lord, they are not fire victims. They are encroachers of the road, TRP road. They are given the accommodation as a street vendors. Our status is the fire victim, my lord. And my lord, page 49.
5 victims of what? Your vegetable, what is there
So
to?
whatever we need the 49 page, they have said that these persons we cannot accommodate because shortage of space in 2007. Now others were accommodated that these real fire victims are not, and there is a direction.
When were you asked, informed that you can't be accommodated?
My lord, page 49.
No, when?
My lord,
When were you informed that you can't be accommodated?
my lord, page 49, that list is published
When?
2007.
And you approached in 2020?
No, my lord, before that, this is. page
Before that is what? Why should this court at all interfere with all these things?
2007 case, my lord, kindly see.
Understood. 2007, why are you waiting till 2020 and moving this court?
No, in between, there is a direction from the honorable court, my lord.
For what?
To accommodate, to make an answer. Page, my lord, 48. This is the case of 2007. It disposed of, my lord.
You filed a writ petition in 1998, isn't it?
Yes.
Who filed?
This is our
Dusty
association.
and Co. You are a vegetable vendor. What is there to do with Dusty and Co?
No, my lord, there is 450 vendors, all are vegetable shopkeepers.
You are a Fancy Bazaar Municipal Market Dealers Association.
Yes, I am of the members.
Okay, that order was passed when?
My lord,
15, 4/6/15.
11/10/2002.
yes,
There was a direction to consider.
yes, and they.
Then it was not considered and not given to you in 2007. Page 40,
40, minus 47, my lord.
47.
Some out of these persons are not given. My lord.
This happened in 2006. Then
Then my lord, page 48.
you file another writ petition. According to while preparing the list of all allottees, the respondent left out the names of the as per the counter affidavit filed where a meeting was held in which the resolution was adopted in respect of construction of the second floor of Iman. A public notice was inviting for the interested person for allotment of Iman. Thereafter, another notice was issued in principle. When matter was taken up on Iman, have it's stating that out of the 35 listed persons, only persons named as so and so could produce the relevant documents and other fields. Accordingly, they were provided with room. However, persons named as in the 24 and though found to be legal heirs of the original title of the after order dated was found. In reference to the rejoinder and the interview, the results discovered may explore the possibility of giving a long term. May explore. That what is there? Nothing is there. Okay. File an affidavit.
No.
This is not a case. This is a fit case for issuing a rule and having it after 20 years. Anyways, Mr. S. Bora, appearing on behalf of the GMC, shall file an affidavit as to whether the petitioner can be accommodated in pursuance to the order passed by this court in dated
My lord, it is, my lord, 4/6/49, my lord. 4/6/15.
It is 4/6/2015, passed in WPC number 3359/2017. 4 weeks time is granted in that regard. Next. 55. The Bolwa, no case. There is shortage of time, so not dismissing it. Okay. None appears on behalf of the petitioner on call. It further appears that on the last occasion also the none had appeared on behalf of the petitioner. Petition according, it seems the petitioner is not interested, for which the instant petition stands dismissed for non-participation.
27.
Okay.
Please, your lordship. Lordship, the petitioner is.
What is your case?
But the petitioner here is agreed by non-payment of part of bill, my lord, amounting to rupees.
How much? 77 lakhs,
77 lakhs. No?
73 lakhs.
Out of the-
Supply of yarn.
Yeah.
What is your stand, Mr. Dhar?
My lord will dispose of matters. My lord have already passed a similar order.
Regarding
Same issue. my lord.
Similar.
Because-
issue.
these, Mr. Dhar, what has happened that day? These matters pertaining to victim compensation.
My lord.
I said these people were same similar matters. I said, okay, dispose of same. Then they gave me a similar order and typed it out and so on. I saw on the first page out there that these persons concerned, they were convicted, and then on down below it has been written in the draft order that whatever may be, a crime has been committed, although no person has been convicted. Okay. Then I thought that no, something has to be looked into. There were 5 matters.
My lord.
I had to pass each and every case individual orders
My lord.
specifically.
My lord.
One case was a person who had nothing to do with that property, or with that deceased.
My lord.
One case is something where it is a case of a motor vehicle accident which comes under 15/11/2014.
Exactly, my lord.
They are going for victims compensation. One case is where there is a direction by the court to pay it to the wife of so-and-so,
Okay.
and the son does it at the age of 46.
So all frivolous petitions.
One is a case, every case, the father has done it who is 80 years, who says that I have my son, daughters, everything, who is taking care of me, but mental agony. But can the victim compensation be given mental agony? No. See, every case is different, very difficult. Yes, what is this case? Oh, that matter.
That matter, my lord. My lord will dispose of the matter in similar line, because my lord, here even in, if you go by the agreement,
Hmm.
in page 14 of the writ petition, my lord, there, the payment, there we have that clause.
Supply the materials cannot be ascertained by this court under Article 223. Considering the above, the last then dispose of directing the respondent to make necessary verification as regards the supply so made by the petitioner, and thereupon if it is found that the petitioner is entitled to the said amount claimed or such amount due to him upon verification, the same be paid. Exercise within 6 months.
No, not six, this is
The exercise be completed within a period of 6 months from the date of certified copy.
my lord. What's wrong with it? There was
Here, what you supplied? Polar blankets,
Cotton yarn, my lord. Yarn, my lord.
yarn. Pursuant to some tender.
The tender process initiated, my lord, in the year 2016, my lord.
my lord, this para 16 is very important for us. Of this order, my lord.
Which one?
This
Para?
16, my lord.
Yes, that is what I've directed.
Yes.
They will verify and make the payment.
And how, my lord, cause my lord, here, this AGMC, they don't have, they has given them the supply order. AGMC has got this supply order from Handloom and Textile. Handloom and Textile also doesn't have money, my lord, budgetary provision. So we'll have to approach finance department, my lord, for this. So my lord has in para 16,
So paragraph no, I said out there, na, yeah, I say in this regard, the respond number 1 and 3 may submit appropriate proposal before the respond number 2
my lord, exactly.
for sanctioning of the amount. If the budget has already lapsed and the
Yes.
respondent shall take appropriate steps so the petitioner gets his entitlement.
Fine. That-
You dispose of silo going to tax report.
So since a similar matter could dispose,
I give your name, huh?
yes, sir.
Ace only for respondent number 3.
No, in the slip.
Lordship.
28.
May I please your lordship,
Hmm.
this writ petition may be closed is infructuous, sir.
Ms. D. Ghosh, the learned counsel appearing on behalf of the petitioner, submits that the writ petition has become infructuous and as such, the writ petition may be closed. Taking into account the said submission, the instant writ petition stands closed as it has become infructuous.
Deeply obliged. lordship.
29.
May I please your lordship?
Hmm.
In this case, the respondent authority allotted land in favor of the father-in-law of the petitioner in the year 1973, that is on 1/5/1973. And accordingly, they are in possessing the land. Suddenly on 1/6/2021, forest official asked the petitioner to vacate the plot of land. On next day, they evicted without issuing any notice, without anything. The allotment of land is at page 22. Lord.
Who is paying for forest?
Lordship, I'm appearing.
Yes, madam. What
Lordship,
is
on the
your,
last occasion, there
did
were,
they submit any representation?
no, not
Hmm.
as of yet.
Huh?
We submitted repeated.
Then what happened?
We were not given the copy of any application that they. And
No,
because at
not
the
to
last,
you. Did they submit it to the forest department something?
no, your lordship.
In view of the submission of Mr. Goswami, learned additional advocate general, petitioner shall submit necessary representation as herein above stated, whereafter the same shall be disposed of within a period of 1 week from the date of the submission of state. Then, did you submit?
Yes, Lordship, I submit.
Where is it?
This is office copy I have, Lordship.
Okay.
Since 7/20.
Mr. F.U. Balbu here, the learned counsel appearing on behalf of the petitioner submits that in pursuance to the order dated 9/7/2021, the petitioner had submitted the representation. Ms. M. Kolita appearing on behalf of the forest department, however, submits that she has no instructions as to whether any representation have been submitted or any orders have been passed. So taking into account the above, the learned counsel for the petitioner is directed to file an affidavit, additional affidavit bringing on record the said representation. So submitted and so submitted. Good stop. List the matter again on 21st of August 2023. In the meantime, Ms. M. Kolita shall also take instructions from the respondent authorities as to whether the petitioners have submitted any representation and whether any decision has been taken on the said representation as directed by the order dated 9/7/2021.
Much obliged, your lordship.
You take your instruction there.
Lordship.
Because there is a direction to dispose of within 1 week
Lordship.
from the representation. Party,
May I please your lordship?
Oh, you are there still?
Relating to settlement of tender lordship system, and it will take some time. I am saying
Okay,
this time,
who is that? Will it take some time?
within a week may be taken up. What has been given to.
Is a stay? Is a stay operating?
There regarding status quo. But
Madam, you are there?
Yes, your lordship.
What is this matter?
Lordship, actually, I'm extremely sorry. I do not have the file as of now because
You have the file?
D. Gogoi was appearing in this matter, but today he could not come to the court due to some difficulty.
The sad part is there is a stay since 2021. Are you not affected? Or you have lost the interest?
No, your lordship. Lordship D. Gogoi was supposed to appear.
Understood.
Lordship may fix any other date.
Understood, yeah. Petitioner is aggrieved against the comparative statement in respect to the tender of national wherein there is a specific violation in the guidelines directed by students. The proposed number one bidder has been identified on the basis of guidelines two, thereby accepting the 10% below estimated demand. Status quo in respect to the contractual job shall be maintained as on today. So affidavits have been filed. Also, please the matter on 22nd of, no, taking into account that there is an order of stay operating in respect to the tender proceedings, the order of status quo operating in respect to the contractual job in question, list the matter on 24th of August 2022, on which date an attempt shall be made to dispose of the petition.
Obliged.
Much obliged, Your Lordship.
31. There's interim order so passed stands extended till the next date.
Obliged.
As Mr. Biswas.
Before my learned friend starts, Lordship, most probably they have to implead a department in this case, Lordship. Earlier it was Social Welfare Department, but a part of that department, Lordship, that is Directorate of Social Justice and Empowerment has been segregated from that department, and now the whole record is with that department, Lordship, and I am not representing that department.
My lord, the Department of Urban Development Department is a party respondent number 6, and if your lordship is the last order, in fact, this honorable court has directed respondent number 6 to file an affidavit in this regard. The last order, if your lordship did, Justice Amar Pathak.
Very good, sir.
तो आसे पार्टी আছে last order to
What party goes?
urban development urban development
No, Social Justice and Empowerment.
oh आपको दे दे.
What is your case?
My lord, this organization is sheltering the homeless people, my lord, in Bongaigaon. They used to get granted aid from the government. However, my lord, from 2019, my lord, no fund has been sanctioned. And we are still sheltering out of our own money, my lord. There are 3 inmates, my lord. At least the government should take these people, my lord. My lord, if that implement is
No, but Mr. Biswas, tell me, this is the 5th of November, you are asking for setting aside. Why?
my lord,
As
because
such, the aforesaid minor will henceforth not come under the control of the Social Welfare Department. Accordingly, there will be no fund for remand to provide grant of concerned so-and-so running so-and-so with the grant of social welfare. Or I request you to convey necessary information to all the concerned NGOs. So these night shelter homes will be with whom?
Earlier it was under the Social Welfare Department.
Now
it is under the Directorate of Social Justice and Empowerment.
Government of India.
No, Lordship, it's a government.
We
of-
have in the state also. The state also has a social justice and empowerment. Read. Very well. You are representing any of them?
So, so far my knowledge goes, the standing counsel for this Director of Social Justice and Empowerment. We are not.
Who?
RM Das, Niki. RM Das. But as because he is not a party here, most probably if he makes a.
we will have to file an implement application.
Who?
We will have to file.
Mr. H. Sharma, representing the Urban Development Department of the Assam, submits,
As well as the Social Welfare Department.
as well as the Social Welfare Department, submits that the schemes as regards the night shelter homes.
Regarding the present case, Lordship. That is the instruction, Lordship.
The
Sorry.
schemes pertaining to night shelter homes are no longer under the Social Welfare Department and is presently under the Department of Social Justice
And Empowerment Department.
and Empowerment Department.
That is the telephonic instruction yesterday I received.
Mr. M. Biswas, the learned counsel appearing on behalf of the petitioner, therefore submits that he may be permitted to file an application to bring on record the said department, to impede the said department.
Lordship.
And deployment.
32.
Lordship, already in this case, the petition number 2 is there. So new president has come out. I have to collect the information there.
Allot the land measuring 5 bighas 4 kathas of land and direct there for that purpose to take necessary steps to place the matter before the SLT. Oh. So you want the land to be not given to somebody?
No, to this society who will start a college here, Monica College.
Where is the society? Made a party?
Society, which ourselves is the society, petition number 1 in the society.
Whom not to allot? Not to allot it to somebody? Whom?
Any person other than the present petitioners.
Why?
Because we want that a college should be started there, and there is also some process.
Who are you?
We are a society. And it's a society, and petition number 2 is the president, 3 is the secretary.
So what credentials you have for the purpose of opening a school?
So the matter is pending, our representation pending before the authority. They have also made some communication in this regard.
No, have you got any document by which it shows that you are in a position to open a school? Then only this court can pass an order that yes, look here, that this is the proposal we have, this is the DPR we have, and as such, this land should be allotted to us. How can you pick and choose that this land I want it?
No, it is in our representation that is reflected.
No, your representation can't be the basis of that, that you can pick and
There is
choose.
also some communication from
Can
the
you
government.
pick and choose that, look here, I want this particular plot of land?
But there is- no,
If you want, if you are entitled for an allotment, you will get an allotment in some land. The government will be very happy to give it to you. But can you say that I want this particular dark number? Even a person who is in possession can't say in a government land that I want this particular land. That as per the, they will be entitled as per the land policy.
Earlier, this land was, land belonged to this land Virastra Seal. And during the Jamindari system, but thereafter, after abolition of Jamindari in the year 1955, the lands became cash land. But they are in occupation till today. Even then, now they are not claiming that land. Now question is this, they want to establish a college there, and for that purpose, they say that earlier.
No, you
And the
have a
matter is-
particular choice of holding a college, opening a college, very well. It is a very noble thing you have done. But the fact that this particular land we want, that particular land, this is absolutely within the domain of the government. Why should this court at all look into this? If they-
Also, the your lordship is correct.
Have you filed an application seeking settlement?
Government has also taken up the matter, though we have pointed out certain land, but we are not restricted with that land.
No.
We want that plot of land which is filed representation, government has also taken some initiatives. Kindly see page 22 and 23. So let this matter be disposed of by the government, that will do. This plot of land or any other plot of land, we are also providing some services to orphans, etc. Our bylaws we have annexed, that is page 12. Those are very noble deeds we want to do, but unless some plot of land is given to us, our work should be stopped. The government has taken initiative, page 22, 23.
Yes, government,
Okay,
none appears for the deputy commissioner.
I'm appearing.
Yes. Tell me.
Letters are there, Lordship, page 22, 23, but regarding a specific plot of land, he cannot, it says the prerogative of the government, Lordship.
Absolute.
Lordship.
Mr. Mahmood has also left that prayer. He says he wants some land for opening up a school. Isn't it?
Yes,
Some land,
no, nearby place.
wherever it is. The instant writ petition has been filed. seeking a direction upon the respondent authorities to allot a plot of land measuring 5 bighas, 4 kathas, 18 lechas, situated at village Devhati, part 1, Tozi number 261, Dag number 3, circle Sirzangram, district Bongaigaon. And for a further direction that for that purpose necessary steps be taken to place the matter before the SDLAC of Bhayapuri in its next meeting. So it further reveals from the records that there's a representation so submitted on to the Principal Secretary, Revenue Department, Government of Assam, on 1st of November 2019. And there also seems to be certain correspondences exchanged between the Deputy Secretary to the Government of Assam Revenue and Disaster Management Department with the Deputy Commissioner Bongaigaon, as well as from the officials in the Bongaigaon department under this Deputy Commissioner Bongaigaon. This court had made a specific query upon the learned counsel for the petitioner as to whether the petitioner can have a specific right or a claim in respect to a specific plot of land. Have a claim in respect to a specific plot of land. The learned counsel for the petitioner submits that the petitioner wishes to open up an institute by the name of Monica
Junior College.
Huh?
Monica Junior College.
Monica Junior College. And if the said plot of land so identified or any other plot nearby is given, allotted to the petitioner, then such an institute can be opened, and that would help a lot in respect to the
In establishment of the college.
that would aid in providing quality education to the quality higher education in the neighborhood. Taking into account the above, this court, taking into account the above, and also upon perusal of the materials, more particularly Annexure 4 and 5, which shows that there has been some correspondences, interdepartmental correspondences in respect to the representations so submitted by the petitioner to the Principal Secretary, Revenue Department, Government of Assam. This court disposes of the petition with a direction to the respondent authorities, more particularly the respondent number 1 and 2, to consider the case of the petitioner as regards the allotment of the land as per the extent land policy 2019 of the Government of Assam. It is made clear that this court is not issuing any direction that the petitioner has to be allotted the land as stated in the writ petition, and the revenue authority shall be at liberty to allot any other land as available if the petitioner meets the criteria as per the land policy.
Nearby the society.
33.
Yes.
Yeah, please, Lordship. Lordship, this matter relates to no, we are living to communicate, instruction has not yet been received.
No instruction. You have filed affidavit, has been filed by respondent number 2, 3, 4, and 5.
National Highway Authority of High, my lord.
This matter is what?
Matter, my lord, in persons of notification, my lord, my land is wrongly reflected as agricultural land instead of commercial land.
So
We have filed a representation before the authority, but till today, my lord, since 2009, my lord. Time is pending, my lord. Was
this
ever-
is as regards compensation for land acquisition.
Lordship.
So if it is agricultural land or
No, my
commercial
lord,
land,
it is commercial land,
very well, if it is a commercial land, you have to show it as a commercial land.
lordship.
Show
But-
it
but-
before the authorities.
We have filed a representation before the authorities, my lord. We have, and there is a report from the lordship,
Has the award been passed?
lordship.
Award has been passed, then why you are not making a reference? Award passed under what provision?
We had to file representation before the authority, my lord.
Award passed under what provision? That is the biggest problem. Let the matter be listed again on 28th of August 2023, on which date the learned counsel for the petitioner shall ascertain under what provision the land has been acquired. Because you need to move there, and then you have to show whatever it is.
Okay.
34. Okay, does. Right here. Yes, what is your case?
My case is, my lord, they are the landless person. They, as a measure of rehabilitation, they are allowed to reside in a plot of land, my lord.
You have sought for settlement.
Yes, my lord.
What has happened?
Now the authority has not considered already deputy commissioner.
And they are trying to evict you.
Yes, ma'am.
How do you say so? Notice issued.
No, without notice. They have
So you have
given
just
a letter.
approached this court.
Court, not mine.
How many petitioners?
Only for, now 16, my lord.
16 petitioners.
Yes.
How much court fee you have paid?
Fee.
60 rupees.
At
16
that time,
petitioners. How is it possible?
it was filed in 2001, my lord.
Huh?
That time.
List the matter again on 23rd of August 2023. In the meantime, the petitioner shall pay the deficit court fee, taking into account that there are 16 petitioners and the court fee of only one petitioner has been paid. Maybe that. Yes, what is this?
My lord, the petitioner before your lordship, this is in fact second round of litigation, my lord. My lord,
What are you challenging?
I'm challenging the order passed by that your lordship will find at page 46, my lord.
What
The
is this?
compilation of judgment, your lordship, which I. Page 46. 35. And your lordship will see. It was issued by additional registrar.
Vinesh Sharma on the.
May I read your lordship?
Inform you to that honorable is to empower Vinesh Sharma.
This,
So your case is that cannot be done.
here two things, my lord. Single member cannot take up, my lord, the matter because subsection 2 of section 4 says bench means judicial as well as, my lord, the single technical member. Number one, this order says, my lord, you decide the matter on the basis of this double bench decision. So it amounts to interfering in the judicial.
In view of the large panel, this would be seen as a one-time exception to the normal constitution of a DB for adjudication of the faith church. Okay, then you are challenging this.
My lord. So we approach this
Is
honorable
it
court.
possible?
Is possible, my lord. The power is conferred upon the chairman of the RCT under subsection 4 of section 4 of the RCT Act to constitute a bench consisting of a single member. And exercising that power, this order has been issued, my lord. I have
Mr. Sharma, that matter where I have
Roger Matthew, your lordship.
that Assam roofing
my lord.
matter, have I not dealt with this aspect?
No, that was a delay condonation matter.
No, I understand, Dilogonal. That was one of the reasons he has given. I think I have dealt with this issue. Because there, Mr. Maheshwari was saying that, look here, there was this technical member, he had no authority. And all this.
That was another case, lordship could not dispose it of. A matter pertaining to levy of terminal charge, my lord. It was heard substantially, but somehow the matter got adjourned. In fact, my lord, I placed before your lordship that the issue of terminal charge is not only covered by a division bench judgment of the tribunal, but decision of this honorable court also. So
Hmm.
it's a covered matter, my lord. There is no substantial question of law is involved, and the chairman of the tribunal, my lord, being known, having known all these facts, my lord, has issued this particular notification in terms of that particular provision, my lord, subsection 4 of
Provision-
section 4.
pro-
It is permissible, my lord.
Okay, that is one. And the second ground is?
My lord, my submission before your lordship is subsection 4 of section 4 empower chairman, your lordship, to issue
No, is that the only ground?
no, my lord. Other
What
grounds
is the
are- my lord,
second
I have
ground?
framed questions, your lordship. Six,
No, no, it's okay. I don't need so many questions.
My
You
lord.
tell me, what is the ground?
My
You are
lord.
challenging that order because on the ground of jurisdiction of the chairman.
Yes.
To have a single bench decide the matter, although he himself admits that it is a matter pertaining to the DB.
DB.
So that is one.
chairman is saying, directing learned single member to decide the matter on the
This is-
basis of division bench.
Mr. Goel, I have understood that point.
My
Now
lord.
come to the
Second,
second.
your lordship, whether the adjudication of claim applications by learned member, RCT, what is sitting amounts to dilation and encroachment on judicial domain as held by Constitution Bench of Honorable Apex Court in Roger Matthew case, your lordship.
For what?
In paragraph 158 of Roger Matthew that I have given your lordship, it says that if the single member who is not judicial background, if decide the matter, it amounts to dilution of my lord and encroachment in the field of judicial side. Because my lord, rule 21 of the Railway Claims Tribunal rule says, my lord, that framing of my lord issues, question of law and question of facts, your lordship. And this question, in fact, this is second round litigation, my lord. This question came up before.
I understood. The second point is a technical member cannot decide alone.
My,
Because of the fact that it is the judicial decision which requires a judicial member to decide.
my number
Okay,
third,
number
your lordship,
three.
in the case of
Don't require cases. Number
Mahabal
three.
Ram, your lordship, Honorable Apex Court held that when the request is made before the member sitting singly to refer the matter to larger bench, generally the member should exceed that request and matter should be referred to larger bench. In the present case, in the first round of litigation, some other writ petitioner approached this honorable court, and this honorable court directed the petitioner to file an application before the learned member single to refer the matter to larger bench. But learned in the present case, my lord, here also, my lord, he has filed an application for referring the matter to larger bench or division bench, but that request was rejected by learned. My lord.
That is not important. Now, number four.
Number 4, your lordship,
And these are the number two.
my lord,
Two questions. One is as to whether the chairman has the jurisdiction
my
to only decide the member technical to decide this in view of the fact that it has to be a division bench. That is his first contention. The second contention is that as the matter pertains to law and fact, a member technical may not be averse to the law, and as such, as per Roger Matthews, what he says, it is only the director, it is only the member judicial who, if at best only one person can do, then member judicial.
This
should.
submission, right?
That's number 3, your lordship, subsection 2 of section 4 says this bench means judicial and technical. So the
That
quorum
is
is
number one. That is again number one.
my lord. So these are the
We
questions.
need not make it complicated. These are the two issues.
Right.
Okay, we'll hear it on 29th August.
No, 29, yes, 29.
List the matter matter having been
affidavit.
heard at length, list the matter on 29th of August 2023 to final.
My lord. And I have given compilation of.
Not necessary, take it.
36.
Don't burden this court with the files. You give it on that day.
My lord.
In fact, you want to give it so much, give
He
it to
can give it to
Mr.
me, my lord. It would
In
be
fact,
helpful.
I have referred all the decision in my
Yeah,
petition.
give it to him, be generous.
Will do, my
Yeah,
lord.
you see,
My
think
lord.
about they are
Morning, I have-
only railway councils, you are big,
My very-
big business.
very rich organization.
That wiser.
My very rich organization, your lord.
No, I'm not aware of the
The
judgment.
rich
you would be relying.
organization may be there, the government may be the very big organization,
In that,
but the question of the council may not be so.
in that day, my lord, I will supply your lordship so that it should not be so wiser.
That's the reason he is not submitting.
Okay.
36.
Okay, list the matter of the three.
37, 38.
May I please, Your Lordship?
Yes,
The matter relates to my lord, non-release of my lord, contractual bill amount, my lord.
I'm appearing on behalf of respondent number 3, my lord. The procurement of the said item ventilator were done based upon the request of the Director of Medical Education Assam, my lord. They said that fund will be transferred to the NHM.
huh?
The fund will be transferred to the NHM, my lord, from the Director of Medical Education, but fund is not transferred, so could not be paid the said amount. So respondent number 2 will be the answerable party.
Who will pay them?
The fund will be transferred from the
You will transfer the fund. The Director of Medical Education
No, no,
shall
we-
transfer the fund to the
NHM.
NHM,
Yes,
and thereupon he will get it.
yes, fine.
The amount is 9 lakhs.
9,01,600.
Whether he is entitled to.
Yes, my lord, the communication were made, my lord, but communications were.
What
made,
is
my
it?
lord.
Does it say that he is entitled to?
Yes, ma'am.
Give me that communication. Now, where is it mentioned that he is entitled to?
Last. In the letter, my lord. First page, my lord.
Your name is what?
My lord, Vikas Medical Device.
Because. 9,01,000. Total name of the vendors, total bill yet to be released. Total amount is 3 crores, 6 lakhs, 42,000. This has been written by the. So this is admitted. Is entitled. We keep this on record. And dispose it of. Get it under 6 months. The export will book. Give your name.
39,
Obligement.
From the date of certified copy. Madam, 6 months, 3 months, I think will be better. Nowadays, I've started passing an order 3 months from the date of survey and to submit compliance before the registry by filing an affidavit. I think then it becomes better. Yeah.
Hello.
Yes.
This is non-payment of the contractor's bill.
Ah.
My lord, we have completed the work, my lord, as per their specification and supplied the materials. Now they said that these materials was not required in the construction. After the long gap, while we have submitted the paper. But there was the measurement of the entire work, my lord, and the executive engineer has signed it, my lord.
No, you are asking for how much amount?
It is about 12 lakhs, my lord.
12 lakhs.
Yes.
Yes, Mr. Upadhyay, what is your stand?
Lordship, we have filed our affidavit, Lordship. The affidavit filed by the executive engineer.
Yes, what is your stand?
Lordship, paragraph 4, Lordship of the affidavit.
Paragraph 4 of your affidavit.
Lordship.
Affidavit filed by the respondent number 4.
Lordship.
The petitioner was entrusted a work of so and so. amounting to amount containing 12 numbers of items and accordingly bill amounting to rupees 1 was prepared and submitted before March. An amount was paid to the petitioner against first that during the preparation the second and the item of preparation was not included in the bill for an amount of paid. The bill for an amount of So your thing is that there's some irregularity
Lost.
and as such, no payment can be made.
This is the stand of the executive engineer.
But they have made a part payment 18 lakhs, they've already paid.
Lost.
They have paid against the first and the second bill.
Second running. bill.
But at the second amount, there is some illegal. Then Mr. Vita Biswas, how can this court decide this?
But let them say then what is the, whether any amount is due or not, let them say. Let them say, they said,
Any other amount is due?
No, no.
You get your instructions on that.
Lost.
Mr. N. Upadhyay, submit, the Learning Council for the Irrigation Department shall obtain instruction as to whether from the state department shall obtain instruction and file an affidavit as to whether any amount is due from the department to the petitioner. The said affidavit be filed by 30th of August, list the matter on 1st of September. Only one page affidavit.
Lost.
40. Well, I would say.
may please the lordship. My lord, this IA has been filed for impeding, my lord. My lord, the read petitioner challenged the settlement order made in favor of the respondent number 5. And the land is in the possession of these applicants, my lord. So they are also, my lord, necessary party, they may be implemented as respondent number 7, 8, and 9. 9 and 10 in the read petition.
Oh, this matter, I remember. You are supporting him
Lordship,
and you are giving it to him. She stays in Calcutta.
Yes, madam.
I remember now.
Yes, madam.
Yeah.
My lord, respondent number 5.
allotment
My lord,
is
she
given
is
to
in
private.
Calcutta, my lord.
Allotment is given to
Yeah,
private
yes.
respondent, lordship.
I know that she's respondent number 5.
Yes, yes,
She stays out there in what you place, Calcutta.
yes.
And she
My lord
never
directed,
stayed out here.
my lord directed on 2nd August to produce the application by the respondent number 3 and 4.
I would have.
Now, Mr.
corrected.
R shall obtain necessary instruction as to when the respondent number 5 had applied for allotment
Yes.
of the land and shall produce the application before this court. Have you got it? Okay, madam, let's do one thing. You keep this. We'll take it up on Monday.
Original record is with me.
My lord,
Who is this?
my lord, the applicant number 1 is the mother of the respondent number 5. And others are brothers and sisters of the respondent number
Why
5.
you are making these people?
My lord, land is in their possession. They are occupying the land and the whatever.
But you want the, are you not challenging the allotment?
No,
What are you challenging?
my lord, because these
Are you not challenging the allotment?
settlement made in favor of respondent number 5 with our consent, my lord.
Understood. Are you not challenging the settlement?
No, we are not challenging. We are supporting this allotment, my lord.
In favor of respondent number 5?
Respondent number 5.
Then what is the use to come before this court?
Applicant number 1 is the mother of the respondent number 5.
What is the use? to-
And others are brothers and sisters, my lord.
Council, that day you said something else. Impugn order dated 9/7/2021 passed by so and so should not be set aside. 9/7/2000 9/7/2021 is which order?
My lord, 34, page 34.
This has been given in the name of Chinu Nazari.
Yes,
my lord.
That is of respondent number 5.
yes.
Are you saying that you are not challenging this order?
No, my lord.
Then matter remains, we dismiss the petition, you are not challenging.
My lord,
This is
we are,
Your only prayer in your petition, no, Mr. Siddharth, your prayer in the petition was to challenging the order dated 9/7/2021. I still remember on that day that you said that you give this land to anybody else. I don't mind, but not to respond number 5. Isn't that what is?
That part was pleaded by Mr. Talukdar myself, my lord. He was not born by that point of time on the last occasion. Because he is going to file an imprisonment petition today before your lordship.
He is the.
You were the petitioner.
I am the petitioner. my lord.
That
Yes.
is the petitioner.
I
Yeah.
plead before your
Why you are here? Come here. No, this is not. That is the problem which is happening. Ah. He wants that.
Yes,
Yes, I remember that. Somebody said.
my lord, land is all along within our possession, my lord.
Understood. You are in Calcutta.
My lord, one of my daughter, respondent number 5, he is in Calcutta. But I.
No. How could the settlement be made in your favor?
My lord, because of my lord, my mother favors that land should be settled in respondent number 5. He is my daughter, my lord. I am the mother of the respondent number 5.
The land belongs to you.
Land belongs to us, my lord. We are occupying the land.
Who is he?
My lord, he is my lord. He is my lord. He is no way connected with the land, my lord.
No, is he connected with you?
My lord, distantly related, my lord, within the same my lord clan, my lord.
Same plan.
Chalo. And what is this IA business?
My lord, IA business is that we want to be part of the proceeding, and we may be.
Who are you?
My lord, I am the mother of the respondent number 5, in whose favor the settlement has been made.
No,
And the
settlement
land.
has been made in respect of respond number 5.
Yes, my lord.
Why should you
And
be made a
we are, land is in our possession, my lord.
So
We
what?
are occupying, my lord.
You have no business out here.
My lord.
You occupy the land on the basis of the rights, on the basis of the right through the respond number 5.
My lord, the respondent number 5 is occupying the land and got the settlement because we are given consent.
Mr. Sikdar, you have no business out there because of the fact that you are occupying. Tomorrow you may say that let my son also be there. Then you may say that my son, there is another person, my domestic
My lord.
help is also there. Let him also be made
My
a
lord,
part.
simple, my lord.
How are you in possession? You are on the basis of a possession because of an allotment being made in favor of the respondent number
He-
5,
he-
and you are respondent number 5.
My lord, respondent 5 is my daughter, my lord.
Are you appearing for respondent number 5?
My lord, I am also, my lord.
Are you appearing for respondent number 5?
Respondent number 5, another advocate was
My lord,
there.
Ah.
There was there.
Earlier.
Okay,
RD was
this is the
there.
matter on Wednesday. Wednesday summit. This is the matter on Wednesday.
My lord, impeachment could be, my lord.
Absolutely no. This is
My
not a
lord,
case for
we
your
may
impeachment.
we may be hard, my lord, part of the.
No implement. You are in Mr. Sikdar, you are in possession of the land. That is why you want an implement so that you delay it.
15 to 17.
Only 1.5 years I'm here. So I know the reason why, yeah. And madam, you retain the records, huh? Until when? Ms. So shall also retain the records. Yes, what are these 3 cases for?
Lordship, it is for a
These are for orders?
no, more orders for that,
One matter, do you need?
for admission hearing, my lord.
For what?
For actually, Lordship, the petitioner firm was executing some works contract under the All India Radio in Arunachal Pradesh in 3 places. And some security deposit, the original security deposit,
To release the security deposit with relation with the works contract with interest accrued upon them. Okay. How much is the amount?
Mala 10% was cut, Mala, because of the liquidated damage, Mala, they have not completed the whole work. And there is a clause, 2%, Mala, each month, up maximum 10%. And we have deducted that 10% portion, Mala.
Taking into account that the matter would require some more further detail taking into account that the matter would require a detailed hearing, list the matter again on 31st of August on which day an attempt shall be made to dispose of the writ petition.
Problem.
Orders kita kira. Yes, Mr. Chakraborty, why are you here?
For two
matters. Some review petition is filed, somebody? Yes, what is this review
Item
petition?
47, I am appearing for the respondent number 5, Lordship. A review has been preferred, Lordship.
Oh, yes, what is that? South
Item
47.
47.
What is this review business?
Lordship, pursuant to the order passed by your Lordship, we had preferred a writ petition because there was a violation of this honorable court's order. In spite of deciding the issue, Lordship, the respondents have issued an
Oh,
order
this
releasing.
matter.
Lordship, they have released.
You want the review only on that aspect?
Lordship, in this matter, the respondents have released an order for giving the salary without deciding the issue, without complying the directions of this honorable court. That we have challenged in a writ petition, and pursuant to that, we have also preferred a contempt, Lordship. That
Then what
contempt is
happened?
pending, Lordship. The contempt is not adjudicated because the pendency of the
Is
review.
this the matter where Mr. Didas is appearing? And your only thing is when the adjudication would be done by that authority, whoever is the commissioner or something, he should take into account certain other documents,
Lordship, that was
which was
direct-
not a part of the records. Yes. First and foremost, you tell me why this order passed by this court has not been complied with till now. Let us consider other aspects later. Ask that, consider this person to be personally present, I think. There is a direction passed by this court in that judgment.
Lordship, there is
We will not consider as regard. And he has given some false document on the
Lordship,
last
that we
day.
have challenged in a writ petition, Lordship.
We'll
We
look
have
into it.
Lordship.
You see, the orders dated are served. The commissioner and secretary to government of Assam is directed to reconsider the case of the petitioner and the respondent number in light of the observations made herein above. And the same should be done within a period of 60 days from the date a certified copy is served upon the commissioner and secretary to the government of Assam. What have you done?
Lordship, there is an order where we have stated that there is an order which is, there's an existent order, your Lordship, non-existent order. And Lordship had asked us to produce that order, your Lordship.
That is my lord.
This is
order
Of
number
the
12.
above materials on record and considering the fact it is observed that there are several of inconsistencies in the case of so-and-so in respect of his first appointment.
Lordship,
This order has been passed again.
Lordship, this is a non-existent order, your Lordship. This order was.
After this court has specifically held that there is, and then also this person has passed. Who is this Bharat Bhushan Chaudhary? I
Lordship,
think this person needs to be brought.
Lordship,
This
yes,
is too much.
Lordship, this is a non-existent order, your Lordship.
Then-
This was, this.
Have you recalled this order?
Lordship, and.
Or
FI
is it the thing that
No,
this order was not at all there?
This order was not at all there, your
It's a
Lordship.
fake order.
Fake order, your Lordship. And
Then why
FI
are you
has been
showing it
filed.
to me?
Because on the last occasion, your Lordship had asked us to produce it, your Lordship.
Yes, what is it? What did I
On
ask?
2022,
Order
your
dated
Lordship.
12 December 2000.
12 December
Serious?
2022, your
But why haven't you passed any order till now?
Lordship, I have taken instruction, your Lordship. A hearing was conducted
Hmm.
and they will be passing a speaking order on that, your Lordship.
When?
Lordship, that they have not informed.
What is the
Sometime-
problem with them? When 60 days have been given? That
Lordship,
was given last July, not
Lordship,
this July, last
last
July.
year.
And you till now you have not passed an order
Lordship,
in
that,
view of the categorical findings being given.
no, that I have
List the matter again on 30th of August 2023, on which date Ms. Deed Musari, the learned counsel appearing on behalf of the
secondary education department. your Lordship.
Secondary Education Department shall
No,
apprise this court as regards the compliance to the judgment and order dated
Lordship, 21/7/2022.
21/7/22.
2020.
To stop. 21/7/2022. It is made clear if there is no order of compliance till then. And complies to the order dated so and so. No, too much.
Lordship, the writ
This
petition and the
I-
contempt may come
You
on
see,
that day,
this,
Lordship.
this judgment, it took me so much of pain in writing this judgment because of the fact that there were so many litigations. And I've made it into one and channelize it. And thereafter also he's doing it.
They have not.
Unless there's something very wrong with your authorities. It's a very serious thing what these people have done.
Lordship, all the orders I have challenged in the writ petition. Pursuant to your Lordship's direction, we have challenged the writ petition also. The order releasing the salary, Lordship. They released the salary without
And
hearing.
also, after
Lordship,
the passing of this order,
of your Lordship's order, they have released the salary, Lordship. That we have challenged. in
but
the
you have
writ
recalled
petition.
it.
Lordship,
Are you still paying the salary?
No, Lordship, they have not. We have challenged in the writ petition, Lordship.
Because in the subsequent writ petition, I oppose. That is why I know something. And it was listed before another court. On that day, it appeared that some fake order was produced.
On the basis of this fake order,
Yes.
you have released.
Not,
Not
I am
released.
not aware of that. Your
Not
Lordship.
That is
released.
not released.
Now,
That
are
has
you
not been
saying
released.
that this order is fake or not?
This order is fake.
So there is no order. Now, what actions have you taken as regards this fake order?
Lordship, an FIR has been filed by the IS Nalbari, your Lordship, Inspector of Schools of Nalbari.
And
And
what is the development?
Lordship, I'll have to take.
But you
Nothing
get
has
as
been
regards
done.
the compliance, we'll see.
Lordship,
Next.
the writ petition, the contempt may come on that day along with. that
No,
petition.
I am not in the contempt business.
Lordship.
But this is a very serious thing. But this time, if, madam, if this is not done on the next occasion, by 30th, no orders are passed. This court will initiate action against them. Whatever order you have to pass, taking into account the directions. Or they have not filed an appeal. Why they have not filed an appeal till now? They are asking that some other documents which they had, they want to place it. That which were never a part before this court. This court had only looked into the judicial making process, judicial decision making process as regards that. And the decision which were made out there was absolutely wrong. Now, why does it require out here, the petitioner require and leave from this court for submitting it? I'm not going to say anything on that. That is the ground of review. But this review is just for to keep out here to find out what you have done.
Lordship.
48 and
Much
49.
obliged, Lordship.
48, 49.
So this 48, 49, I am appearing for the respondent railways. These cases are filed for restoration of a case dismissed for non-prosecution.
Who has dismissed it?
The different court.
Why?
Because there is action, my lord. The concerned advocate was absent. He was
Who is
suffering.
the concerned advocate?
He was ill.
Huh?
He was ill, my lord, on that day.
Who was the concerned
Yeah,
advocate?
that is S. Toikia, my lord. And others advocate already left the practice during Corona, my lord. But basically, my lord, the writ petition, that is to be adjudicated, my lord, whether we have any right or not.
But, Now, what do you want in this petition?
Well, the petitioner here is telling that they are occupying railway land, my lord. And for the last 30 years, they are doing some business over the land, my lord. Now eviction notice has been issued.
You have been evicted also.
No, not yet evicted. my lord. Then appeal has been filed before the district judge. That was dismissed. Again, the dismissal, we have filed the writ petition.
Then,
There is no stay, but my lord,
so they have not done anything.
no,
And even after the dismissal of this,
my lord, basically their
this
question.
was done on 30/8/2022. Almost 1 year has passed. You have not thrown them out.
My lord, railways, my lord.
Or railways have not. Then why you are asking
No,
for it?
because sometimes it was also informed that they will give the license to regularize our position, my. But the thing is that not if the reputation is not restored, my lord, then things what we want to bring is that now we have paid for lease of the land, lease, and now they have said that railway have said by the affidavit that they want to widen the this road, my lord, widen the road towards railway station, my. Now later on we have come to know that they would lease out the land to the others. If it is lease out to land to the others, then why not us? That is thing may come up. Kindly, my lord, restore the petition and petition may be heard at any date, my lord. My lord, may I submit one thing, my lord? My lord, this writ petition is against an order of the learned district judge dismissing the
appeal filed under this public
Read these
premises.
matters on 21st of August 2023.
All right.
50,
What is this matter? Early hearing?
Yes,
What matter is this?
okay, compensation,
Huh?
custodial debt. My lord,
Custodial debt.
my lord,
It's a case of custodial debt.
yes, my lord. Kindly peruse paragraph number 5 of
Okay.
application.
Taking into account the instant application has been filed seeking early hearing of the instant application.
My lord,
Instead, the accompanying writ petition. Taking into account the contents of the said writ petition, which pertains to a violation of Article 21 of the Constitution. This court disposes of the instant interlocutory application, thereby fixing the matter on 22nd of August 2023 for final disposal.
My lord,
I stands disposed.
court number may be corrected.
Huh?
Court number, court,
What court?
court of category.
Which is?
So at the time of filing this writ petition, the court number has been wrongly written as 10189.
Don't worry,
The
it will
court
come.
number 1019.
It's okay. You want this matter to be taken up?
Division bench, my lord. My lord, this matter is a division bench.
Then how can I do this? To order to cancel court. Has the division bench at any point of time taken up this matter?
No, my lord.
Code number, what should be the code number?
You are stated in the
এটা কাম কৰক, হা?
number 5.
Paragraph number 5.
এইখনত লিখি দিব। The registry shall inquire, এইটো আগৰ order to cancel. The registry shall inquire as to whether the instant writ petition has to be listed before the single bench or the division bench, taking into account that the instant writ petition, in the instant writ petition, the challenge made how did the person die?
Under the police custody.
Huh?
Under the police custody.
Mr. Counsel, why you are going before the division bench then? On police atrocities.
Police arrested the petitioner.
No, this is a case of police atrocities.
He was the malad at UTP malad, under trial prisoner.
So would it come under the police atrocities? The police case?
Police case?
No, if it is the atrocities of the police, it comes before the division bench.
Lordship, my lord, he put the malad at wrong malad.
No, that is okay, but
That's why malad, it was referred to the division best, 10198. But it should be 10192. This is a single bench matter.
This is a single bench matter. Then,
No, my lord. 1019.
Mr. Counsel, you finalize what is it. Otherwise, I would have taken up the matter on 22nd. If you are not here, the learned counsel shall finalize as to whether the matter pertains to a single bench or division bench. And thereupon, liberty has, however, been given to the petitioner. No, the learned counsel for the petitioner submits that a matter pertains to the division bench. However, Mr. J. Hendik, appearing on behalf of the Revenue and Disaster Management Department of the Government of Assam, submits that the instant writ petition comes within, is to be listed before the single bench, be that as it may. The registry is directed to inquire as to whether the matter pertains to the division bench or the single bench, taking it and thereupon list the matter accordingly.
51.
Obliged.
Yes, what is it?
My lord, wait please, my lord. I filed one IA for correction the order. My lord, due to my mistake, my lord, on my part, I wrongly submitted that the date of birth of the petitioner is 1/5/1962, whereas it is 1/7/1952, my lord, as per the service book.
Where?
My lord, I have made the amendment in my IA, my lord, page 5 of the IA, my lord.
Here.
Fault was on my part.
So it is 1/5,
My lord, it is 1/7/1962.
1962.
Fine.
The instant application has been filed seeking correction of the order dated 19/5/2023, passed in WPC number, passed in the accompanying writ petition, wherein at paragraph number 6, the date of birth of the petitioner has been mentioned as 1/5/1962. It is the submission of the learned counsel appearing on behalf of the petitioner has drawn the attention to which document?
My lord, the service book, my lord, at page,
Where?
my lord, service book. I'm coming to the page number, my lord. Of the,
Where is it?
My lord. My lord, page 33 of the writ petition, my lord.
Of the writ petition?
My lord.
That's I have submitted that the learned counsel for the petitioner has drawn the attention to the service book of the petitioner, wherein it has been mentioned as 1/7/1962. Taking into account the above, taking into account the service book which have been enclosed as Annexure 6 to the writ petition, this court corrects, this court rectifies the mistake so committed in paragraph number 6, and thereby observe that the date of birth. No. No. This is why you are asking for this. In your admit card, what is your date of birth?
My lord, my admit card. But it is written 16 years, 8 months. Page 20.
No, it's the case of the petitioner is that the date of birth in terms with the admit card issued by the Board of Secondary was 1/5/1962.
My lord, it should be 1/7/1962.
It couldn't have. However, in the basis of the HSS, the date of birth was inserted in the service book as 1/7/1962. Then
My lord,
that is your entire case in your writ petition. Why should this court correct it unless you seek an amendment out there? Huh?
my lord, I just submit.
No. Mr. Counsel, nothing doing.
My lord,
Absolutely no. Because of the fact, what is your statement in your petition? Let's see.
And in this writ petition, we have filed our affidavit also, Lordship.
Hmm?
In the writ petition, we have filed our affidavit.
Uh.
This date of birth in the admit card and date of birth in the SSLC pass out certificate is different, Lordship. That is his case, Lordship.
That is what. Now he wants to correct and all these things, nothing doing.
You know,
Now it was, here it has been mentioned, na? His HSLC certificate says 18 years, 8 months,
Lordship.
as on 1st of March, 1979. That is it.
18 years, Lordship.
While
Why should I correct it?
my lord, as per my admit card, it should be 1/7/1962, my lord. Due to certain miscommunication, I had wrongly fitted that this 1/5/1962.
Here the parties allowed this application by considering the amendment to the order dated so and so. What is the amendment sought?
My lord, amendment sought for the date of birth in the order.
What is the order what amendment you are seeking?
My lord, my lord would kindly come to point 6 of the order, my lord. Passed by
No. What is the amendment you are seeking out here? That as per the service book of the petitioner, his date of birth is recorded as 1. However, during the course of the submission, the learned counsel for the petitioner had erroneously stated his date of birth to be 1/5/1962 instead of the correct date of birth, as owing to certain miscommunications. I have not stated that you have stated. Here I say the case of the petitioner herein is that the date of birth in terms with the admit card issued by the Board of Secondary Education was 1/5/1962. However, on the basis of the SSLC certificate, the date of birth was inserted in the service book as 17. I have not stated that you have stated. Then what is there? If you see as per the it's a admit card, then it is 1/5/1962. The instant application has been filed seeking correction of the order dated, seeking amendment to the order dated 19/5/2023. A perusal of the application shows that as per the service book of the petitioner, his date of birth is recorded as 1/7/1962. However, during the course of the submission, the conducting counsel for the petitioner had erroneously stated his date of birth to be 1/5/1962 instead of the correct date of birth, that is 1/7/1962, owing to certain miscommunication. This court have duly taken note of paragraph number 6 of the said order, wherein this court had observed that as per the date of birth mentioned in the admit card, it was 1/5/1962. However, in the service book, it was shown as 1/7/1962. The date as to whether the petitioner's date of birth is 1/5/1962 or 1/7/1962 shall be duly taken note of at the final disposal, during the final disposal of the writ petition. And the reference so made in paragraph number 6 shall not affect the final adjudication in the writ petition. On the basis thereof, the instant application stands disposed.
ये उतारने वाला मेरे साथ
নালাগে এটা হ্যাঁ এটা নালাগে নালাগে এটা নিবলে পাই আপনার এই ইয়ালে দেখা কৰি দিও ফোন background is pretty. Like it, I mean, glass of time. Karu lage ne? Karu to asne na. Hello. Use no one. Huh? Good to watch it. Money use no one. Use correct. তার মধ্যে একটু লইল বেলেগ ফটো দিও সাউন্ডার বললেন এই পড়ার লোকের ফটো তার কথা বলতেও বললে মানে যদি সাইডার নেই এটাই কয় আছে
এটা নাই
ইউজ করেন না हम कह देंगे फिर लॉटरी यूज करने पे एक बार फिडर नहीं नहीं ये हो जो ना पैसा पर ना আমি ওইখানে তো প্রবলেম পেছে নাকি এই সিস্টেম অনলাইন তো আপনি ইয়ার আছে নাকি আপনি একটু করা আছে এই করি আছে সিস্টেমটা
Hi,